Okay, good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies, or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense. And you also have the right to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you're in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Whether bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Finally, could everyone raise their right hand for me, please? These swear affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God. Okay, well, let's get started on the ladies' side. I believe Miss Bailey is going to be the first person. Miss Bailey, good morning, ma'am.
Good morning.
You're charged with driving under the influence of alcohol, that's a misdemeanor offense. Bond is going to be set at $5,000. You're also charged with failure to stop. Bond is going to be set at $500. Because these are misdemeanors, your preliminary hearing date is going to be set for January 3rd, 2023 at 8:30 in the morning. However, if you post bond, that date is going to get waived and you'll have a new court date sent to you in the mail. Do you want me to see if you qualify for the appointment of a lawyer? I'm sorry, ma'am.
Can you say that one more time?
Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. I'm going to find that you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am. You're free to go back. Ms. Brown? I'm sorry. Give me 1 second, Ms. Brown. Ms. Brown, you're charged with 1 count of simple battery. I've set the bond at $4,000. You're going to have a preliminary hearing date set for January 3rd, 8:30 in the morning. That date will get waived upon your bonding out. It's going to be a stay away provision on this bond to stay away from a Maisha McQueen. Do you understand that, ma'am?
Yes.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Okay, ma'am, I'm going to find that you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
For how long?
I'm sorry, ma'am.
How long will I have to stay away from the person?
So right now, that's set as a condition of bond. So as long as this case is pending, that provision will be in place. If there is a change in that condition, a judge will have to sign off on it. So if Miss McQueen, if she wants this to be changed, she can contact the solicitor's office. They will do their own independent investigation. And if they determine that this condition should be changed, they will make that request of the court. But you are not in a position to advocate for that. Do you understand that? So I'm meeting you for the first time. I don't know, other than what was presented, what happened, but at this point, you should govern yourself accordingly. And what I mean by that is that this stay away provision, if you violate it, you could face aggravated stalking charges, which is a felony where bond is denied. So have I answered your question?
Yes, sir.
Okay. Do you have any other questions for me?
No, sir.
Okay. You're free to go back. Give me 1 second. No, stay there. You're Miss Paul?
Yes.
Okay, stay there. All right. I got the message, and we'll deal with the person accordingly. So
Yes, Your Honor.
thank you. Ms. Polk, ma'am, you're charged with 1 count of driving under the influence of alcohol. Bond's gonna be set at $5,000. You're charged with 1 count of driving a vehicle with no insurance. Bond's set at $1,000. You're also charged with knowingly driving a vehicle with a suspended registration. There is a separate charge that did not make it onto your bond. And that appears to be bond order. I'm sorry. That appears to be following too close. I'm going to set that bond at $500. And I'm going to write it in on your bond paperwork, just so you can be able to bond yourself out and get yourself out of jail today. You're going to have a preliminary hearing date set for January 3rd at 8:30 in the morning. That date will be waived once you bond out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay.
Yes.
All right. Give me 1 second. Okay, ma'am, I'm going to find that you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, you're free to go back. Miss Petty? Miss Petty, ma'am, you're charged with 1 count of terroristic threats or acts, and this is being charged as a felony. I've set a bond at $5,000. You're going to have a preliminary hearing date set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you will have a we'll receive a new court date in the mail. There's going to be a stay away provision on this bond, and to stay away from Althea McIndoe. Do you understand that?
Yes, that's my nephew and niece's mom.
Okay.
I
So
haven't seen them for years. This is an old warrant. I couldn't turn myself in at the time because I didn't have nobody to watch my kids.
I understand. And it looks like it was what, from 2017?
Yes, I haven't seen them ever since.
Okay. But you do understand that you're not to have any contact with them.
Yes, but to be honest with you, we have seen each other throughout the years that I have not been able to turn myself in. We have met up, the kids and me, her, and the kids met up at the skating rink. We don't really speak, but we have seen each other and stuff. It hasn't been a problem. But I know to stay away from them.
Okay. And I'll make a comment on that in a moment, but do you want me to see if you qualify for the
Yes.
appointment of a lawyer? You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Now, this whole thing of terroristic threats, it is a crime. And you're free to voice your opinion about whatever you think. But try to just keep it civil. Okay, can you do that for me, ma'am?
Yes.
Okay. You have any questions for me?
No.
Okay, ma'am, you're free to go back. Ms. Stanley,
My bond was, Judge, how much you said my bond was?
5,000. Miss Stanley, ma'am, you're charged with 1 count of simple battery. Bond is going to be set at $4,000. This is a misdemeanor offense. You're going to have a preliminary hearing date set for January 3rd at 8:30 in the morning. That date will get waived upon your bonding out, and you will get a new court date in the mail. There's a stay away provision on this bond to stay away from a Anisha bail. Do you understand that? Do you have any questions about that? I'm sorry, ma'am.
No.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
How much do you make per hour?
$15.
Okay. I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir.
Okay, ma'am. You're free to go back.
Your Honor, that's all the females.
Okay. Thank you.
Thank you.
Let's switch over to the males. Hold on 1 second. I get myself together. We're gonna deal with Mr. Mahone last.
Yes, Your
Okay?
Honor.
Okay. Was that something, Mr. Ray, you wanted to let me know?
Yes, Your Honor.
Oh. All right. We're gonna start with Mr. Alexander.
Good morning, Your Honor.
Good morning. Sir, you're charged with 1 count of loitering or prowling, 1 count of entering an automobile. The entering automobile is a felony offense. You're gonna have a $1,000 bond set for the loitering or prowling. And you're gonna have a $5,000 bond set on the entering automobile.
Okay.
You're gonna have a preliminary hearing date set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, that's fine.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, sir, you're free to go back.
All right, thank you.
Mr. Austin. Mr. Austin, sir, you're charged with several misdemeanor offenses. Driving under the influence of alcohol, bond's gonna be set at $5,000. A red light violation, bond's set at $500. It says improper or erratic lane change, bond's gonna be set at $500. Driving too fast for conditions, bond is set at $500. And reckless driving, bond is set at $1,500. You're gonna have a preliminary hearing date set for January 3rd on these offenses. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, Mr. Austin?
I was supposed to start on the job there.
I'm gonna find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me? I'm sorry, sir.
No, sir.
Okay, you're free to go back, Mr. Austin. Mr. Berry.
Good morning, Your Honor.
Good morning, Mr. Berry, sir. You're charged with several serious felonies. And I've granted bond on all of these offenses.
Yes, sir.
You're charged with one count of aggravated assault. I've set a bond of $15,000. You're charged one count of discharging firearm near a highway. That's a misdemeanor. You're charged with the bond is going to be $2,000.
Yes, sir.
Reckless conduct is also a misdemeanor. Bond is going to be set at $2,000. Cruelty to children in the first degree. Bond is going to be set at $5,000. That's a felony offense.
Yes, sir.
And one count of possession of a weapon in the commission of a crime, which is also a felony offense. And bond is going to be set at $5,000.
Yes, sir.
You're going to have a preliminary hearing date set for January 4th, 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive
Yes,
a
sir.
new court date in the mail. Would you
Yes,
like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, Mr. Berry?
No, sir. I'm still in school.
Okay. I'm going to find that you qualify, sir. And I'm going to appoint a lawyer to represent you. Do you have any questions for me?
If I get a lawyer, can I fire the lawyer that you getting?
Yes, sir.
That's my only question.
Okay. Just notify the lawyer that's been appointed
Yes, sir.
that you've hired another lawyer, and then that lawyer can move to withdraw and everything can be above board.
Yes, sir.
Okay.
That's it.
You're free to go back, Mr. Berry.
All right.
Mr. Fleming. Mr. Fleming, sir, you're charged with one count of loitering or prowling. Bond is set by schedule, which means it's automatically set at $1,000. You're also charged with one count of criminal trespass, and I've set the bond at $2,000. You're going to have a preliminary hearing date set for January 3rd, because these are two misdemeanor offenses. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Mr. Fleming, are you currently working?
Sir.
I'm sorry.
No, sir.
Okay. I'm going to find that you qualify, Mr. Fleming. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back, Mr. Fleming. Mr. Hayes.
Morning, sir.
Morning, Mr. Hayes, sir. You're charged with some misdemeanor and some felony offenses. You're charged with 1 count of simple battery. Bond is going to be set at $5,000. You're charged with 1 count of false imprisonment. Bond is going to be set at $10,000. And you're charged with 1 count of aggravated assault. Bond is going to also be set at $10,000. There's going to be a stay away provision on this bond to stay away from an Anisha Asbel. Do you understand that, sir?
Yeah.
Your preliminary hearing date is going to be set for January 4th. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the
Yes.
appointment? You said yes?
Yes, sir.
Okay. You do qualify, Mr. Hayes. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, sir, you're free to go back. Mr. Hoskins.
Good morning.
Good morning, Mr. Hoskins. Sir, you're charged with 1 count of simple battery. Bond's going to be set at $5,000. That's a misdemeanor offense. There's going to be a stay away provision on this bond to stay away from it looked like the name was Michael or Michael Glover.
Yes, sir.
Do you understand that?
Yes, sir.
Okay, your preliminary hearing date is going to be set for January 3rd. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Looks like you refuse to fill out the form. Does that mean you're going to represent yourself, or you're going to hire your own lawyer?
Yes, sir. I'm going to hire my own lawyer.
Okay, do you have any questions for me, Mr. Hoskins?
No, sir.
Okay, you're free to go back, sir. Mr. Jenkins.
Your Honor, Mr. Jenkins has court in another courtroom today, Your Honor.
Yes, yes.
What you like to do about that? Do you?
No. I'll do a continuance order, and we'll just bring him back tomorrow. Mr. James. Mr. James, sir, you've been charged with 1 count of false imprisonment. That's a felony offense. Bond's going to be set at $5,000. 1 count of aggravated assault. Bond's going to be set at $15,000. 1 count of battery. Bond's going to be set at $5,000. 1 count of cruelty to children in the 3rd degree. Bond's going to be set at $2,000. 1 count of robbery. Bond's going to be set at $10,000. 1 count of obstructing or hindering an emergency phone call. Bond's going to be set at $5,000. You're going to have a preliminary hearing date set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. There's going to be a stay away provision on this bond.
Yes, sir.
To stay away from a Brandy Patterson. Do you understand that, sir?
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Sure.
Are you currently working, Mr. James?
Yeah.
About how much do you make per hour? I'm sorry. 17? Okay. All right, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me? I'm sorry.
Not that I can think of right now.
Okay. All right, sir, you're free to go back. Mr. Johnson. Mr. Johnson, sir, you're charged with 1 count of aggravated assault. That's a felony offense. Bond is going to be set at $20,000. You're charged with one count of discharging a firearm near a highway. Bond is going to be set at $5,000. One count of reckless conduct. Bond set at $5,000. One count of cruelty to children, first degree. That's also a felony offense. Bond is going to be set at $5,000. One count of possession of firearm or weapon during the commission of a crime. Bond is going to be set at $10,000. That's also a felony offense. And one count of theft by receiving stolen property. Bond is going to be set at $5,000. You're going to have a preliminary hearing date set for January 4th at 8:30 in the morning. That date will get waived upon you bonding out, and you will receive a new court date in the mail. You're also going to have a stay away provision on this bond to stay away from a Derez Leonard and Nigel Mitchell, also an Xavier Wise. Do you understand that, sir?
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You said no?
Yeah.
Okay.
You talking about court appointed lawyer?
I'm sorry?
You talking about court appointed lawyer?
Yes, sir.
I'm good.
Okay. Do you have any questions for me?
No, it's all right.
Okay, you're free to go back. Mr. Lawrence. Mr. Lawrence, sir, you're charged with several misdemeanor offenses, driving under the influence of alcohol. Bond's going to be set at $5,000. Reckless driving, bond's going to be set at $1,500. And I added an extra zero to that inadvertently. One count of too fast for conditions, bond is set at $500. Improper lane change, bond is set at $500. Expired driving vehicle with an expired tag, bond is set at $500. You're going to have a preliminary hearing date set for January 3rd at 8:30 in the morning. That date will get waived upon you bonding out, and you'll receive a new court date in the mail. Do you want me to see? Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir. Yes, sir.
Are you currently working, Mr.
Yes, sir.
Lawrence? About how much do you make per hour?
24.
Okay. I'm going to find that you qualify, sir,
Yes, sir.
to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. And we're going to hold Mr. Mahone until the end.
Yes, Your Honor.
So let's call Mr. McGrath.
You have Mr. Murphy in there, Your Honor.
I'm sorry.
Mr. Murphy.
Sir, I do have him.
Did you wait on him?
Well, I was going to call him next.
Okay. He's here.
Yeah. Okay, Mr. McGrath.
Commissioner McGrath. Yeah, I'm gonna have to turn it up a little loud just because he can't hear.
Okay.
He's an older gentleman.
Mr. McGrath, can you hear me, sir?
Yes, I can.
Okay, sir, you're charged with one count of battery. That's a misdemeanor offense. Bond is going to be set at $5,000. There's also going to be a stay away provision on this bond to stay away from a Jamie Holland. Do you understand that, sir?
No, can you please repeat that?
There's a stay away provision on this bond to stay away.
Prevention? Is that what you said?
I'm sorry, I didn't understand his question.
Your Honor, he's repeating what you just said.
Okay, sir, you are currently going to be ordered to stay away from Jamie Holland. Do you understand that?
Who? Jamie, what?
Holland, Holland.
I don't know this person.
Okay. Do you recall being in a dispute with someone yesterday? In an argument, in a fight, or a dispute with the person yesterday?
Your Honor, I was assaulted and forcibly ejected from my home by the staff of housing for affordable housing. 85.
Yes, sir.
Yes, Your Honor.
So that person that you had the dispute with yesterday is the person that I am ordering you to stay away from.
I'm at a loss. Thanks.
Okay, from my end, the audio is going in and out, so I don't really hear everything Mr. McGrath is saying.
Your Honor, he is stating that he doesn't know who this female is.
Oh, okay.
Yeah.
Well, sir, you've been ordered to stay away from this person.
How am I to do that?
Are you seriously asking me how you're supposed to stay away from someone?
That I don't know, that I've never met. I don't know what you're talking about. How can I stay away from a person like that?
Well, the allegation is that you hit this person over the head with a black and orange elongated flashlight. So that's the allegation, sir.
Jamie Holland? No, it wasn't Jamie Holland. It was the fellow called CD, the house mister at.
Oh, sorry. Mr. McGrath, you're going to have a preliminary hearing date set for January 3rd at 8:30 in the morning. That date will get waived upon your bonding out. If you violate this bond condition, you will be arrested and held in jail without bond, charged with aggravated stalking. So I'm not going to go round and round with you about the allegation that brought you here. I don't know if you know the person or not. Do you want me to see if you qualify for the appointment of a lawyer? Did he say yes or did he say no?
I said no.
Okay. You're free to go back, Mr. McGrath. Mr. Murphy, Mr. Murphy, sir, you're charged with 1 count of criminal trespass. This is a misdemeanor offense. I'm going to set a bond at $3,000. Do you understand that, sir?
Yes, sir. They said that that warrant was from 4 years ago, sir. I can't get a signature bond for someone on that.
No, sir. This is from November, allegedly occurred November 14th of 2018. And the
Yeah.
allegation involves something with your mother. Your mother never told you that she sought for have a arrest warrant?
Oh, sir, I have a great relationship with my mother. This don't even sound right. I'm from 2018.
November 14th, 2018.
I'm highly confused about this, sir. I'm sure she will clear all this up. I'm highly confused.
Well, hey, all I'm saying is that the allegation is something occurred at Debbie Lane, and that allegation is that you damaged property belonging to your mother.
My mother doesn't even stay on Debbie Lane, sir.
Okay. So let me explain maybe something to you. This is a warrant that an officer came in to request from a judge. So the only way that officer gets the information is that your mother told the officer that information.
For damaged property.
Let me ask you this, Ms. Murphy. Do you believe police officers have the time to just go and just put charges on people?
Like, do you?
Hold on.
So-
Hold on for a second.
So, Mr. Murphy,
Yes, sir.
who do you believe called law enforcement to come to your mother's house and for your mother to say something about you? Who in the world can you believe thought that up?
Sir, it's to be honest, it's so many people against me. This is not even what I expected. I have no clue, sir. I really don't.
Let me ask you this. Do you believe that that officer woke up that day and said, I want to go put charges on Deontay Murphy, so I'm going to just make some stuff up about something that happened at his mother's house? Do you believe that?
Honestly, I don't know what to believe, sir. And like I had said, my mother doesn't even stay over there. But I understand.
I'm gonna say this to you, Mr. Murphy. And law enforcement officers in the room, they know it, and I know it. Sometimes the people that you think are your friends are the ones that are snitching you out. And then when that happens, they're like, oh man, I don't know. Why they arrest you? What's going on? And that's the same person that snitched you out.
Thanks, sir. You're right.
So you could continue living that life and thinking the people that are smiling in your face are your friends, or you can get smart and say, you know what? I gotta keep, as they say, keep my enemies close, because I want to know what my enemies are thinking. what my enemies are saying. So I'll just tell you this, sir, and this would be a piece of free advice. From what I've read, your mother is a person that snitched on you. And you can believe it or not. But that's what happened. And you can get smart or you can stay, as they say, game goofy. And you can keep walking around with these people next to you that they just can't wait to snitch you out.
Right, sir.
So I hope my words have helped you. But sir, I'll tell you this. Most law enforcement officers I know, they want to go to work and go home.
Correct.
They have no interest in what your life is or what's going on with you. They have no interest at all. They got their own stuff that they're trying to deal with. So I hope my words may help you, sir, as you move along in the future. But you're free to go back. Mr. Ray. Sir, you're charged with several felony offenses, and I am setting bond on each of these offenses. You're charged with one count of party to the commission of a crime, bond is set at $5,000. Charged with one count of burglary, bond is set at $10,000. One count of interference with government property, bond is set at $5,000. One count of crossing the guard line, that's a felony offense, bond is set at $5,000. One count, violation of Georgia Controlled Substance Act, bond is going to be set at $10,000. One count of criminal trespass, bond is set at $5,000. And one count of use or possession of drug-related objects, bond is set at $1,500. Because of these felony offenses, you're going to have a preliminary hearing date that's going to be set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, Mr. Ray. I'm going to appoint a lawyer to represent you. Do you have any questions for me? I'm sorry, sir.
Sir.
Okay. All right, you're free to go back, Mr. Ray. Mr. Roberts. Ms. Roberts, sir, you're charged with one count of criminal trespass. Bond is going to be set at $1,000. Because it's a misdemeanor offense, your preliminary hearing date is going to be held on January 3rd at 8:30 in the morning. This date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? I'm sorry, sir.
Yes, sir.
Are you currently working, Mr. Roberts?
Yes, sir.
But how much do you make per hour? I'm sorry, sir.
$12.
Okay, you do qualify, Mr. Roberts. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Oh, sir.
Okay. All right. You're free to go back, Mr. Roberts.
All right. Yeah, cool.
You too. Mr. Smith.
I'll just ask you.
Give me 1 second, Mr. Smith. Mr. Smith, sir, you're charged with 1 count of theft by taking. And this is a felony offense. I'm gonna set your bond at $5,000. You're gonna have a preliminary hearing date set for January 4th at 8:30 in the morning. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
I don't know how to answer that, Your Honor, because this situation happened at my job. But I do make $22.50 an hour and 24 on the weekend. But I don't know how to answer that question because I don't know if I still got a job.
Okay, so let's break it down. Once, do you want me to even make the attempt to see if you qualify for the appointment of a lawyer?
Sir.
You said yes?
Yes, sir.
Okay, I'm going to find that you qualify, Mr. Smith. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Can I bring the money up to the jailhouse to bond out? Go through a bond?
You have those three. You have 3 options available to you. You can bring the entire amount to the sheriff's department. They'll hold that until your case is over, and then they'll return that amount to you. You can go through a bonding company. Bonding company is going to charge you a fee. Whatever they charge you, they keep. You can, if you got property that has at least 3 times the assessed amount of your bond, you can put that property up. Sheriff's Department will place a lien on that property, and when your case is over, they'll take the lien off.
So if I got jury in my property right now that way out to the amount of my bond, I can leave that with the sheriff office. I got a whole bunch of jury up there. So I'm just saying, if they want to get some of that jury, they can have it.
Well,
I'm just trying to figure out, can I bond myself out right now? 'Cause I got money and jury in my property right now.
well, yes, sir. You can bond yourself out, but the sheriff's department is not a pawn shop.
Oh, I'm just, if it hold equal value, they can appraise the diamonds or whatever they want to do. I mean, but I go through a bondsman. I go through a bondsman. I don't have the same amount in my property.
I mean, and you can do that. And if you believe that the property has that kind of value, you can have somebody come in and you release your property to that person. That person can take that property to a pawn shop or whatever and get the cash and come back. But sheriff's department is only going to deal in cash. They're not going to deal.
Listen, I was just impatient. I wanted to walk off without having to call nobody, but I can get the cash up here. That's needed. Appreciate everything.
Yes, sir. Yes, sir. You can do whatever you want, but I'm just letting you know that they're, as they would say, they're lanes. So sheriff's department is not going to be taking your jewelry.
Yes, sir.
and trying to appraise your jewelry. But they will do what is appropriate under the law.
Yes, sir.
All right. You're free to go back. Mr. Is it Sifo?
On y'all.
Good morning, sir. You're charged with 1 count of possession of firearm by a convicted felon. I'm going to set a bond at $10,000. You're charged with 1 count of a misdemeanor terroristic threats. And I'm going to set the bond at $3,000. Because of the felony, you're going to have a preliminary hearing date set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah.
Are you currently working?
No.
Okay. I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, sir. You're free to go back. Mr. Terrell. Mr. Terrell, sir, you're charged with 1 count of aggravated assault. This is a felony offense. I'm setting the bond at $10,000. 1 count of discharging a firearm near a highway, setting the bond at $5,000. 1 count of cruelty to children in the 1st degree. Bond's going to be set at $5,000. 1 count of possession of a weapon during the commission of a crime. Bond is set at $5,000. And 1 count of reckless conduct. Bond is going to be set at $2,000. You're going to have a preliminary hearing date set for January 4th. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Did you say yes? Are you currently working?
No, sir. I'm still in school.
Okay. I'm going to appoint a lawyer to represent you. I find that you do qualify. Do you have any questions for me, Mr. Toya? Okay, sir. You're free to go back.
All right, thank you.
You're welcome. Mr. White. Mr. White, sir, you're charged with 1 count of public indecency. Bond is set by schedule at $2,000. And you're charged with 1 count of driving under the influence of alcohol. Bond is going to be set at $5,000. These are both misdemeanor offenses. So you have a preliminary hearing date set for January 3rd at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer? I'm sorry, sir.
Yeah.
You do qualify, Ms. White. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Can you repeat the bond?
Yes, sir. You got a total bond of $7,000. It'll be a little bit higher because Sheriff's Department is required to add fees onto the bond, and they have that schedule, which I don't have. So it'll be a little bit north of $7,000.
Okay.
Okay. You got any other questions?
And yes, I was wondering, can I ask what was the reason for them stopping me?
Okay. I'll tell you what's here. Basically, it says that they observe you leaving a McDonald's at 2125 Mount Zion Parkway, and observe you stop to basically urinate is what they're saying. And that's the public indecency part.
Yeah.
And they believe when they made contact with you that you were under the influence. And so that's why they did what they did. But as you stand here, you're an innocent person, and the state has the burden of proving every element of each offense beyond a reasonable doubt.
So what that means?
It means that, one, that's why I make the statement in the beginning of not talking about your case.
Okay.
Because
That's it.
okay. All right, sir. You're free to go back.
Williams.
Mr. Williams.
Yo, oh man, come on. Come on, man.
Okay, you're charged with one count of criminal trespass. I'm going to set the bond at $1,000. This misdemeanor offense, you're going to have a preliminary hearing date set for January 3rd at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Yes, sir.
About how much do you make per hour?
Shit, 1,200. Oh, per hour, I'm tripping. $24 an hour.
Okay.
Not 12, I'm tripping.
All right, sir. I'm going to find that you qualify. Going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. Mahone.
Just give us 1 second. We're gonna clear the room.
Okay.
Before we do, Judge Johnson, last name Johnson, he wanted you to repeat his bond total amount.
Okay. Let me see.
It was 17, I believe.
Oh, it's Aramonte Johnson.
Yes, Your Honor.
Looks like total bond is going to be $50,000.
And then James, and that's the last one.
James.
Y'all should have been listening. Hold on.
Okay, Mr. James is $37,000.
Okay. All right. All right, Judge, we're clearing the room. Give us 1 second.
Okay.
Judge Gardner, what was that first one? I think it was Breonte Alexander.
First person
Yeah,
on the left side was Alexander, and he had 1,000 for loitering or prowling and 5,000 for entering an automobile.
Okay, and I think I got that James guy incorrect. You said 37,000?
Yes, 5,000 for false imprisonment, 15,000 for aggravated assault, 5,000 for battery, 2,000 for cruelty to children third degree, which is a misdemeanor, 10,000 for robbery, which is felony, and 5,000 for obstructing or hindering an emergency telephone call.
Perfect. Thank you.
No problem. Is this Mr. Mahone? Jeez.
Yes, Your Honor.
Okay.
Good morning, Your Honor.
Good morning, Mr. Mahone, sir. You're charged with 1 count of criminal trespass. I've set bond at $3,000. You're charged with 1 count of burglary. I've denied bond at this time for that offense. You're charged with 1 count party to the commission of a crime. I've set a bond at $5,000. 1 count of crossing a guard line, which is a felony offense. I've set bond at $5,000, and one count of interference with government property, and I've denied bond on that offense. You're going to have a preliminary hearing date set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer? I'm sorry, sir.
Yes, sir.
I'm going to find that you do qualify, Mr. Mahone. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
How did I get the burglary charge?
The burglary charge,
Wasn't it because it was somebody pressed charges?
no, this is an officer reported. So the burglary allegation is based upon a belief that you and another person cut fence at the jail and entered into the property, and that they were appeared to be maybe or the allegation is that they were people who were inmates at the jail were throwing down bed sheets for them to receive contraband. So that's the extent, and I believe it says that it was caught on camera. So you may want to just sit down and have a conversation with your lawyer about the allegations that are being charged towards you. Okay, sir?
So I got another.
Yes, sir.
So if I pay my bond for the 3 charges, for my 3 charges, would I be able to get out?
No, I've denied bond right now on the burglary and the interference with government property. That decision will be revisited, and the district attorney's office, they can turn around and say, hey, we're gonna set them a bond, but it's going to be up to them. Right now, based upon the allegations that I've read, I'm going to deny bond at this stage.
Even if this is my first offense?
Yes, sir.
Thank you.
You can't, the first offense thing, like you don't get a free murder. Like you can go your whole life and you shoot and kill somebody. It's not a free shot. And the allegations, based upon what I read, I think there needs to be further thought as to whether you're a person that should be on the street. Okay?
Yes, sir.
All right, you're free to go back.
Thanks, real quick, man. This little business, Your Honor.
Yes, sir. I will, as they say, I'll be here all week. Make sure you tip the servers.
Will do, will do.
and I'll see you all tomorrow. Thank you for your service and thank you for your assistance.
Thank you, Your Honor.
Thanks, Judge.
Thank you, Miss West.
All right, ma'am, your name?
Stephanie Huey.
All right, Ms. Huey, you are here on an out-of-county warrant. Bond on that warrant's no bond, so you'll be held on that warrant, no bond. You're also out on bond in Orange County, case number 2022 MM007869AO for a battery domestic violence. I'm gonna take no action on that, so you're still out on bond on that charge, okay? But you got that VOP warrant, okay? All right, good luck to you, ma'am. Oh, hold on one second. I'm going to appoint the Office of the Public Defender to represent you on the battery that's pending in Orange County. The VOP, that's a different county, so you have to take care of that there, okay? Morning, counsel.
Good morning, Your Honor. My first name is Matthew, last name is Ferry. I represent Matthew David Lennon, who is standing to my right. Your Honor, I did speak with the state regarding the bond conditions in this case, and the state, I think, is agreeable to bond being set in the amount of $500 with the conditions of no contact, no return.
Say, is that correct?
Yes, Your Honor.
All right. All right. Reviewed the charging affidavit. I do find there is probable cause. We'll set bond at $500. Order that you have no contact with the alleged victim. Also order that you do not return to the residence. Does he need to go back one time, or?
Probably, yes.
Okay. Allow him to go back one time with the presence of law enforcement to get any personal belongings. Other than that, you can't go back to the residence, okay? Also going to order that you possess no weapons, firearms, or ammunition, okay? All right, thank you, sir. All right, your name?
McNutt. Dominique McNutt.
Yeah, all right, Mr. McNutt, this was reset for today for an offer. Council, what are we doing with this one? Well, there's a couple of them, huh? Yeah.
The offer in case number 2022 MO 1369AO is an adjudication of guilt, credit time served, and court costs. Ms. McNutt would like to accept and enter a plea of no contest.
All right, you got a plea form? She's signing it now. All right, Mr. McNutt, you heard what your attorney had to say. Is that your understanding of what's happening here today?
Yes, sir.
All right. I think they were already appointed.
Yes.
Yeah, but typically not. But maybe. But they were already appointed in this one yesterday, it looks like. All right, ma'am, your name?
My name is Dominique McNutt.
I was handed a plea form. Did you sign the bottom of this plea form?
Oh, yes, sir.
All right, you understand that by resolving your case here today, that there's not going to be a trial and that you're waiving the rights that are listed at the top of the plea form?
Yes, I understand.
All right, you have the opportunity to go over this plea form with your attorney?
Yes, sir.
All right. Are you on probation for any other offense?
No, sir.
All right, you understand if you're not a U.S. citizen, a plea of this offense will subject you to deportation?
Yes, sir, I understand.
Yeah, and do you understand that if you've ever been convicted of a sexually motivated or sexually violent offense, a plea of this offense could subject you to involuntary civil commitment?
I understand.
All right, you under the influence of any drugs, alcohol, or medication affecting your ability to understand what's happening here today?
No, sir.
All right, well, accept the no contest plea, adjudicate you guilty. How many days you got? 2?
2.
Yeah. Sent you 2 days in the Orange County Jail, credit for the 2 days that you already served, so you'll be released as it relates to this charge today, okay?
Thank you, sir.
All right, thank you.
Have a good day.
You too.
And so her out on bond, you're taking no action? Your Honor.
Judge, with regard to her out on bond, are you taking no action?
Yeah, taking no action on the out on bond.
Thank you.
Yeah.
Good morning, Your Honor.
1 year to pay. All right. All right, sir, your name? What happened? happened to Lillian Smith? Did we,
His mental health, Your Honor.
okay.
I will waive, Your Honor.
All right, you were PD was previously appointed. We'll waive her appearance, enter. Do we want to reset her or do you want to just set her for
Oh, no, I'll waive, Your Honor. I don't think she'll be able to make it tomorrow either.
okay. So we'll just set her for pretrial conference? Or-
I would just ask that you stay the bond, Your Honor.
I got tagged in kind of late, so here, yeah, I wasn't in jail mindset yet. Yeah, so we'll stay the bond at $250.
If I could ask for a no return, Your Honor?
No return, yeah, we'll order no return.
Thank you.
All right, I do find there's probable cause. Well, the probable cause, that's why this was reset from yesterday.
Right. Or a plea.
Right, but he found PC yesterday, right?
He didn't address it.
He did?
reset it for a
Oh.
plea.
Okay, never mind. All right, sir, your name? Alex, what's your last name?
Cervera.
All right. And sir, your name?
It's Thomas Cromer.
I'm sorry, your name?
Thomas Cromer?
All right, and you're the alleged victim in this case?
Yes, I am, and I'm his stepfather.
Okay. All right, well, this was a arrest warrant, so a probable cause determination's already been found. So what we're doing for today's hearing, just so everyone knows, we're just setting bond and determining appropriate conditions of bond. So before we do that, I'm going to ask you some questions, okay?
Absolutely.
First, do you raise your right hand to be sworn? Do you swear or affirm the testimony you will give be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, so some of the things we can order in a domestic violence case and as no contact, no return. We can do no hostile contact, that way you can have contact with each other, just if no fighting, arguing, anything like that would be a violation of the conditions of his release. But the questions I have for you, number one, are you guys currently living together?
Yes, at the time he was arrested, he was living at the house.
Okay. Do you want him to continue living at the house?
Yes, I do, Your Honor.
All right. Are you afraid of him?
No, Your Honor, Alex is an autistic child with ADHD and sensory disorder. And we found out after he was already put into the behavioral center and he came out, he went to his psychiatrist, and it turned out that there was an imbalance in his medications. Once that was fixed, he has been back to normal circumstances, and I do not see him as a threat to me whatsoever.
All right, thank you. State, any questions?
No, Your Honor.
All right, Your Honor, I have asked, can I make a request?
Yes.
I asked that the bond be set to 0 if that's possible, or minimal that you're permitted to do. I don't know, this is unprecedented, I guess, but I don't find him to be a threat in any regard at all, so.
The bond on the warrant signed by Judge Young is $2,500 on count 4. I'm not inclined to somebody think.
I mean, I don't.
Yeah, just let me think for 1 second.
Yeah, sure,
This
sure.
is it's admittedly kind of unique. This isn't your run of the mill, false imprisonment. I do find the probable cause determination's already
I don't
been
know.
made.
I didn't understand what the false imprisonment was either, so.
No, it's okay.
Thank you.
Yeah. He does not qualify for pretrial release, that's correct? Or-
No, he doesn't.
All right, here's what I'm gonna do. I'm gonna stay the bond on count 4 at $2,500. On counts 1, 2, and 3, I'm gonna set bond at $100. So it's $2,800 total. If you go through a bail bondsman, it's usually 10% of that. But if you need a lower bond, you're gonna have to go see the judge in this division.
Yeah, could you explain, I'm sorry that this is taking so long, but could you explain to me why there was a warrant issued to him?
All I know is that there was a warrant and that it was signed. The judge reviews the affidavit. There's an affidavit that goes to a judge to review, and then if the judge finds there's probable cause, he typically signs a warrant and sets a bond. And in the state of Florida, the allegations of battery, they come in at no bond until they see a judge. So the ones that he's seen the judge on here today, I'm setting them about as low as I can at $100, but the $2,500 that was set by the previous judge, I'm gonna stay that bond at $2,500, okay? No, yeah, the conditions are gonna be that you have no hostile contact. That just means no arguing, no raising your voice, right, you know.
Yeah.
I have to order those to be conditions of release. Also going to order that you possess no firearms, weapons of any kind or any ammunition. You can go back to the residence, not going to order no return to the residence. I'm also going to appoint the Office of the Public Defender to represent you, okay? So you're going to have an attorney to help you out in case you run into any other issues down the road, or you want to modify that or anything like that, okay? All right, thank you, sir. All right, sir, your name?
Jose Alexis Gonzalez Saxton.
All right, sir, you're here on one count of violating a no contact order. Reviewed the arrest affidavit. I do find there's probable cause. Bond is currently at none. I'll appoint the Office of the Public Defender to represent you in this case. Currently being held on a separate case in 2022 CF 13440AO. Say, do you have a position as to appropriate bond and what to do on the felony case?
I apologize, Your Honor. My paperwork didn't have the felony case, so can you give me that case number again?
2022 CF 13440AO. He's being held on that case, so he's technically not out on bond on that case, but that's the case in which the no contact order was issued.
Just one moment, Your Honor.
Hold on. This says I confirmed he's still incarcerated for case 2022 CF 13440.
Yes, he has $1,000 bond. Is So, Your Honor, it appears as though there were 2 domestic violence incidents, because there's also a 22 MM 7555, and the bond has been revoked in that case.
Has the PD been appointed in that case? If not, I'm going to appoint the Public Defender's Office to represent you in the case that you're being held no bond on. That's okay.
Well, Your Honor, as he hasn't bonded out yet, I don't know if you can revoke the bond and then.
Yeah, and the bond's already been revoked in the misdemeanor, so I'm going to take no action on the
Felony?
on the felony bond. You still have $1,000 bond on the felony charge you're being held on. As it relates to this,
He is entitled to a bond, Your Honor, but you can take into consideration the fact that this appears to be the 3rd incident with the same victim.
yeah, all right. All right, so in this case, based on the circumstances that we've been discussing in open court, I'm going to set bond, in this case, at $25,000. Order again that you have no contact with the alleged victim. And that means phone calls, text messages through third parties, no contact with the alleged victim whatsoever. You do not possess any weapon, if you are a release, or even if you're not, you do not possess any weapons, firearms, or ammunition. Counsel, do you know if the gentleman and the alleged victim were living together? Okay. I'm going to order that you two maintain separate residences if you bond out too. So if you are able to get out, you can't live together. Maintain separate residences, no contact with the alleged victim, no weapons, firearms, or ammunition, okay? Bond's $25,000. So Sir, you have the right to remain silent. I would advise you to exercise that right. You have an attorney appointed to represent you. All we're doing today is setting bond, so I'm taking no action on the felony case that you're still being held $1,000. Your bond's revoked in the misdemeanor case you're being held on. Bond in this case is $25,000 because all three of those cases involve the same victim. So, you know, I don't know how else we can get through to you. You got to leave this person alone until further order of the court. So that's all we're doing today, okay? All right, good luck to you, sir.
Thank you.
Yep. All right, sir, your name? All right, Mr. Gorham, you are here on a warrant for 3 counts, 1 count of false imprisonment, domestic violence, 1 count tampering, hindering, communication, or tampering with a witness, victim, or informant, and 1 count battery, domestic violence. Probable cause determination's been previously made. Do we have the affidavit in this one? State, do you have you reviewed the factual, I just haven't reviewed the factual allegations yet, so I don't know, do you have a position on bond?
No, Your Honor, I do not.
Well, we'll review it real quick. I'll appoint the Office of the Public Defender to represent you on this case. I'm just gonna look at the allegations in the affidavit that was submitted to issue the warrant, and then what we're doing today is just setting appropriate bond and any conditions of release. The conditions of release are going to include, no contact with any of the alleged victims, no return. Well, let me see. I want to read the allegations before we do Thank you. All right, the conditions on the warrant are no contact with the alleged victim, to maintain separate residences, and no weapons or firearms. Separate residences will work. If you need to go back to the residence one time with the presence of law enforcement to get any personal belongings, I'll let you do that.
Did I speak, Your Honor, or no?
Well, you have the right to remain silent. It's usually a good idea to exercise that right today. We're not getting into the veracity of it. There's been a probable cause determination made. We're gonna set bonds and conditions of release. Because there's no victim here, I have to order that you have no contact with the alleged victim until further order of the court. Go ahead, counsel.
He qualifies for pretrial release. I would ask for pretrial release, Your Honor. Additionally, she is not residing at the house, so I would ask for the maintenance of residence and the one-time return with law enforcement. If he goes back with law enforcement and she is not there, he'd be allowed to stay.
Well, separate residences is separate residences. If she's not there. Hold on. It's okay, hold on.
I'm sorry, Your Honor.
Yeah, it's okay.
I have nowhere else to go. She has family.
This is.
Where, then you can, if she's there,
Sorry, something. All right, in this case, on count 1, I'll set bond at $1,000, count 2, $250, count 3, $250, with those conditions that we talked about. Also,
Your Honor, he can't afford the bond. He does qualify for pretrial. I was asking for pretrial release in this particular case.
sorry. I do see you qualify for pretrial release. We'll order that you be released on pretrial release under those conditions that we talked about. One other thing, also condition that you comply with any and all recommendations or orders from DCF, because the allegations do include a minor child being present. So if DCF has any recommendations or orders, you need to comply with those as a condition of your release as well, okay? All right, good luck to you, sir.
You're welcome.
All right, this is case 2022 CF 14448AO. Sir, what's your name? All right, Mr. Perez, you're here on one count of aggravated assault with a deadly weapon, one count battery, domestic violence. I'll appoint the Office of the Public Defender to represent you. I've reviewed the arrest affidavit. I do determine that there is probable cause. Set bond on count one. $10,000. And count two, $500. Conditions of release that you have no contact with the alleged victim. No contact means no contact. No Facebook, text messages, email, no communication through third parties. Also that you order that you possess no weapons, firearm, or ammunition. And also order that the two, you and the alleged victim maintain separate residences. If you need to go back one time to the residence to get any personal belongings, you can do that with the presence of law enforcement. You can't go without first coordinating with law enforcement. Other than that, you two must maintain separate residence, okay? Good luck to you, sir. All right, sir, your name?
Marshal Stephen Polston, Your Honor.
All right, Mr. Polston, this is 2022 CF 14454AO. You do qualify for pretrial release. Will order you be released as a pretrial release. That's a non-monetary form of release, but it's going to require, I'm going to order some certain conditions. Number one, that you have no contact with the alleged victim. That you do not possess any weapons, firearms, or ammunition, and that the two of you maintain separate residences. If you guys were living together, you can't live together anymore. You can go back one time with the presence of law enforcement to get any personal belongings. Other than that, you must maintain separate residences until further order of the court. I'm also going to appoint the Office of the Public Defender to represent you, okay?
Yes, sir.
All right, good luck to you, sir. All right, ma'am, your name?
Alia Simpson.
All right, and your name, ma'am? I just have, what? Kalia? Kalia? Do we have Camille?
He's in the misdemeanor section, Your Honor.
All right. All right, Kalia Simpson. This is case 2022 CF 14440AO. One count of aggravated battery, domestic violence. I've reviewed the arrest affidavit. I do determine there's probable cause. I'll appoint the Office of the Public Defender to represent you. I'll set bond on this count at $10,000. Oh, I'm sorry. I didn't see you there. Ma'am, your name?
Aisha Simpson.
All right, and you were the, one of the alleged victims in this case?
Yes, sir.
All right, can you raise your right hand to be sworn? You swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. All right, your name again? I'm sorry.
Keisha Simpson.
All right, Ms. Simpson. What's your relation to these two young ladies?
My mother and my sister.
All right. All right. So what we're doing today is setting bond and conditions of release. Were you guys living together?
Yes, sir.
All right. Do you still want to live with them, or are you scared of them?
I live with my husband.
Okay. Do you want them to live at the house, or you want me to order them to live it somewhere else?
I'll drop our charges.
You want to drop all charges?
Yes, sir.
We're not going to do that today. We're just doing conditions of release, okay?
Okay.
Are you scared of them?
No, sir.
All right. My reading of the allegations indicate someone was stabbed in the stomach. How's he doing?
He's doing okay, just in pain.
So, do you want to have contact with them?
I went to the hospital last night.
Or do you want to have contact with them, the defendants?
Sure.
Sure? I mean, you didn't seem too sure. I'm just, that's what I can order them have no contact with you. I can order them have no hostile contact with you. It just means no arguing, no raising your voice, anything like that. So as you're the victim in this case, you can tell me what your feelings are about conditions of their release, and we'll see what we can do. So my question for you is, are you scared of either of them, both of them?
No, sir.
Okay. Do you want to have contact with them?
Yes, sir.
All right. Do you want them to be able to reside in the house?
Yes, sir.
Anything like this happened before with them?
No, sir.
All right. State, do you have any questions?
No, Your Honor.
All right. All right. We'll do Kylie first. Based on testimony here today, I'm going to set bond at $5,000 on count one. I understand what you're saying, but, you know, someone did get stabbed in the stomach, so that the court has to take that into consideration. Also order that you have no hostile contact with any of the alleged victims. You can have contact, it just means no arguing. Things start getting heated, the no contact order is a one-way street. It's only on you, it's not on them. So if they start arguing with you, the order is imposed only on you. So you gotta be the one that walks away or whatever. So order that you have no hostile contact. Also gonna order that you possess no weapons, firearms, or ammunition, okay? As a condition of your release. All right, and that should take care of Miss Kalia Sampson. Or Simpsons, excuse me. Ma'am, your name?
Camille Simpson.
Camille?
Yes, sir.
I do remember seeing that one, actually. I've reviewed the arrest affidavit. I do determine that there is probable cause. Does she qualify for pretrial release?
No, Your Honor.
No? I'm gonna set bond on your case at $250 with the same conditions, okay? So you have $250 bond conditions being no hostile contact, no weapons, firearms, or ammunition, okay?
Sure.
All right, also, I'll appoint the public defender to represent you as well to the extent there's a conflict, the public defender can file the appropriate motion, okay?
Your Honor?
Yeah.
With regard to Kalia Simpson, 22 CF 14440, the other victim who was stabbed is Vernon Brown. That person isn't present here, so I think there should still be a no contact. And unfortunately, he's not listed as a victim, but
I know, I saw that when I was reviewing it.
Yes, he's
this
my
morning.
husband.
They kind of, it's her husband, she says. Yeah. He wasn't listed as a victim.
And the
I
person
understand what you're saying, State.
And the person who is, the other person who is listed as a victim was actually a witness. That's the father, so. I would prefer, Your Honor, if you do a no contact with, and we could name him specifically, Vernon Brown.
All right, I've appointed the Office of the Public Defender to represent you both. I do agree with the state, you know, the law requires us to consider the testimony of the victim. Because Mr. Brown is not here, I have to order that you have no contact with Mr. Brown until further order of the court. If you need to get that modified and take some testimony from Mr. Brown, your attorney can do that for you, okay? But until then, this court's gonna order that you have no contact with Vernon Brown until further order of the court. You can have no hostile contact with this particular victim, and you don't need to, yeah, just no contact with Vernon Brown, okay? All right, good luck to you. Yeah. And that's just for Kalia, right?
Oh, so only Kalia has no contact.
With Vernon Brown, I think the.
Right, because,
There was,
with the Camille.
her
it
victim was a different victim.
Yes.
Right, okay. Thank you. So. Ma'am, your name?
Alicia Brady.
This is Brady.
Yes, ma'am.
All right, Ms. Brady, you are here on one count of battery, dating violence, and one count of criminal mischief. I've reviewed the arrest affidavit. I do determine there's probable cause. You do qualify for pretrial release, which is a non-monetary release, so you should be released as it relates to this charge today, with certain conditions, okay? Because there's no victim here, I have to order that you have no contact with the alleged victim. That's text messages, emails, Facebook, TikTok, third parties, no contact with the alleged victim. Also order that you two maintain separate residences. If you were living together and you need to go back to the residence to get any personal belongings, you can do that one time with the presence of law enforcement, okay? Other than that, the two of you must maintain separate residences. Also going to order that you possess no weapons, firearms, or ammunition, okay? I'll also appoint the Office of the Public Defender to represent you, okay? Good luck to you. Mhm. All right, so we need to call, and they're gonna.
The Spanish might answer, but just let them know you're trying to reach the Creole.
Okay.
Good morning.
Good morning. Is,
Creole interpreter?
yeah, Creole interpreter?
Yes,
All right, perfect. All right, have you been previously sworn?
I have.
All right, and your name for the record?
Isabel DeRocher.
All right, Mr. Rocher, this is case 2022 MM 8374AO.
Okay.
All right, sir, what, does he need to put the headset on?
He can if you want, sir. It depends on you.
Oh, I don't, whatever's easier for you. It's,
Oh, the headset is easier.
okay, yeah, all right. All right, he has the headset on.
Please let me allow me to establish connection. Sorry.
Okay, you, okay.
Okay, everything is fine.
All right, sir, what is your name?
Monsieur Kijan. Mark Sony Joseph.
All right, Mr. Joseph, you are here on one count of battery, domestic violence. I've reviewed the arrest affidavit. Do find there is probable cause. Do qualify for what's called pretrial release. It's a non-monetary release. So you'll be released as it relates to this charge today. I'm also going to appoint the Office of the Public Defender to represent you. Your conditions of your release will include that you have no contact with the alleged victim. I understand it's your wife. I understand the allegations are what the allegations are. I have to order that you have no contact with the alleged victim because she's not here today. Also have to order that the two of you maintain separate residences until further order of the court. You have an attorney appointed to represent you who can file any appropriate motions to have those modified should you need to have those modified. I'm also going to order that you possess no firearms, weapons, machetes, or ammunition. Okay?
Yes.
If you need to go back to the residence one time to get any personal belongings, you may do so with the presence of law enforcement, okay?
Okay.
All right.
Okay.
All right, thank you, sir. And thank you, Madam Interpreter.
You're welcome, sir.
All right, I think that's the only one.
All right. Thank you. Have a good day.
You too, thank you. All right, ma'am, your name?
Anna Castro.
All right, Ms. Castro. You're here on one count of battery, domestic violence. I've reviewed the arrest affidavit. I do find there's probable cause. You also qualify for what's called pretrial release, which is a non-monetary release. You'll be released as it relates to this charge today with the following conditions. Because the victim's not here, I have to order that you have no contact with the alleged victim. That's text messages, emails, TikTok, Facebook, Instagram, third parties, no contact with the alleged victim. Also have to order that the two of you maintain separate residence. If you need to go back to the residence one time with the presence of law, to get any personal belongings, you may do so with the presence of law enforcement, okay? Also appoint the Office of the Public Defender to represent you in order that you possess no weapons, firearms, or ammunition, okay?
Sir,
All right, good luck to you.
thank you.
All right, sir, your name?
Frederick Duncan?
All right, Mr. Duncan, you're here one count of. He's listed as a co-defendant. I think that's just an error. You're here on one count of battery, domestic violence. I've reviewed the arrest affidavit. I do determine there's probable cause. You also qualify for what's called pretrial release, which is a non-monetary release. You'll be released as it relates to this charge today with the following conditions. Because there's no victim here, I have to order that you have no contact with the alleged victim. That's text messages, emails, any electronic communication, or communication through third parties. Also order that you maintain separate residences. If you need to go back to the residence one time or to get any personal belongings, you may do so in the presence of law enforcement. Other than that, you must maintain separate residences. Also order that you do not possess any weapons, firearms, or ammunition. And I'm going to appoint the Office of the Public Defender to represent you, okay?
Okay.
All right, good luck to you, sir.
Thank you.
Your Honor,
Mhm.
DCF was notified of this
Oh.
incident.
Yes. DCF was notified, so as a condition of release, you just need to comply with DCF as if they have anything to comply with, okay? All right, good luck. All right, sir, your name?
Hicks, Craig Hicks.
All right, Mr. Hicks. Say, did this come in, it's in the misdemeanor stack, but did it come in as a felony? Or did it come in as a,
Your Honor, I apologize. I'm still reading through it. I just got the affidavit in court. It's an over the line, so.
right, it's a little different. I think it came in as a misdemeanor. Although, yeah. While you're reading that, we'll go through the other stuff. All right. All right, Mr. Hicks, you're here on one count of battery.
Your Honor, there is also a witness.
Okay, thank you. Ma'am, your name?
Sheila Hicks.
All right, Ms. Hicks, please raise your right hand to be sworn. You swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, your name again, I'm sorry.
Sheila Hicks.
All right, Ms. Hicks, you're the alleged victim in this case?
Yes, sir.
You've been sitting out there for a while. Were you able to, you kind of understand what's happening here today? We're just setting bonds and conditions of release?
Yes, sir.
All right, are you currently scared of Mr. Hicks?
No.
All right. You two currently living together?
For 40 years, yes, sir.
Is it your desire that he be able to return to the residence and you two live together?
Yes, sir.
Anything like this ever happened before?
No, this is not typical behavior for Craig. My children, my grown children and I had some concerns in the weeks prior to this, and he had an appointment with his psychiatrist, and then this happened. He's got Asperger's and anxiety, and also is bipolar, and his medication is not correct.
Okay.
So he has an appointment to get that adjusted. This is not, and he's also agreed to take some anger management and counseling as he gets out.
State, any questions?
No, Your Honor.
All right. All right, so I do find there's a probable cause for misdemeanor battery. You do qualify for what's called pretrial release, which is a non-monetary release. So you're going to be released as it relates to this charge today with the following conditions, okay? No hostile contact with the alleged victim. Hostile contact just means no arguing, no raising your voice, yelling, anything that could be considered hostile. You can't do it. Also, that you possess no weapons, firearms, or ammunition. she said your medication's not correct, so I was gonna order you take your medication as prescribed, but, I'm not gonna do that because.
Adjusted, sir.
Right, that's fine, that happens. So I'm not gonna order that you take the medication as prescribed, because if it's taking it as prescribed is not working, then, you just need to have that adjusted, okay?
Yes, sir.
All right, say anything further?
No, Your Honor.
I'll also appoint the Office of the Public Defender to represent you, so you do have an attorney appointed to represent you in this case going forward, okay?
Yes, sir, thank you.
All right, good luck to you, sir. Thank you, ma'am.
You're welcome, thank you.
Oh, you didn't qualify for the services of the public defender, or you make too much money, so I'm not gonna appoint them to represent you. So you do not have an attorney, so if you want an attorney, you need to hire one.
I understand.
All right, thank you. Yep. Thanks. Thought you were telling me you didn't qualify for PTR, so that's a problem. Yeah. All right, sir, your name? All right, ma'am, your name?
Natalie Rivas.
All right, ma'am, raise your right hand and be sworn, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. And your name again?
Natalie Rivas.
All right, Ms. Rivas, you're an alleged victim in this case, is that correct?
Yes.
All right. You've been sitting out there, you understand kind of what's going on here today?
Yes, sir.
All right. You currently afraid of, your name again, sir? I'm sorry.
Jose.
Jose, last name?
Lazoya Mendoza.
Lazoya, you currently afraid of Mr. Lazoya?
No, in fact, I feel the most safest with him. He's my husband, and what's it called? Like, the incident. He took medicine. He has a back injury on his spine, and he was just switched over to different kinds of pain management. And one of the things that they tried was a steroid. And I even spoke to them about it, and they said that it's just something that needs to be crossed off or whatnot. Just try it. But and on the bottle it does say, along with drowsy, dizziness, it can do depression, suicidal thoughts, anger, bits of
Right.
all that
So
stuff.
you two currently living together?
Yes, sir.
It's your desire that you want him to come back home?
I'm sorry?
It's your desire you want him to come back home?
Yes, sir, because he takes care of my kids while I'm working.
Gotcha.
Yeah.
Anything like this, yeah, I think I asked you, and you kind of explained it, but nothing like this ever happened before, I think you said?
No, sir.
All right. State, any questions?
No, Your Honor.
All right. I've reviewed the arrest affidavit. I do find there's probable cause. I'm gonna set bond at $250 with the following conditions: that you have no hostile contact with the alleged victim. No hostile contact just means no arguing, no raising your voice, anything like that, and that you possess no weapons, firearms, or ammunition. I'm also gonna appoint the Office of the Public Defender to represent you. So I have an attorney appointed to represent you going forward, okay? All right, good luck to you, sir, and thank you, ma'am.
Okay, thank you.
Yep. There's hers too. That was the other. All right, sir, your name?
Prescott.
What happened to Vaz? Abadel Vaz? Oh, she's not. All right, sir, your name?
Trevor Prescott, sir.
All right, Mr. Prescott, you are here on one count of battery domestic violence. You do not qualify for the services of the public defender, so I can't appoint them to represent you. It just means you make too much money, so if you want an attorney, you need to hire one, okay?
Sir.
I reviewed the arrest affidavit. I do find there's probable cause. You do qualify for what's called pretrial release, which is a non-monetary release, so you'll be released as relates to this charge today with the following conditions, okay?
Sir.
Because there's no victim here, I have to order that you have no contact with the alleged victim. I also have to order that you maintain separate residences. If you need to go back one time, if you need to go back to get personal belongings, you can go back one time with the presence of law enforcement to get any personal belongings, and you gotta go stay somewhere else until further order of the court.
Okay.
All right. I'm also gonna order that you possess no weapons, firearms, or ammunition, okay?
I don't have any.
Yeah, that's all right. Just as a condition of your release, you're not gonna be able to do that, okay? All right, other than that, you'll be released as it relates to this charge today with those conditions, okay?
Sir.
Yeah.
They told me to let you know if I own the house or if I'm the tenant,
Yeah, I just ordered that you maintain separate residences. If you're living there, she can't live there. So, until further order of the court, okay?
How do I go about making sure I do that properly?
You probably want to hire an attorney.
Yes, sir.
Yep.
Where do I sign? Thank you.
Good luck.
Thank you.
All right, sir, your name?
Abe Dilvaz.
All right, Mr. Vaz. You are here, this is case 2022 MM8372AO. It's one count of battery, domestic violence. I've reviewed the arrest affidavit. I do determine there's probable cause. I'll appoint the Office of the Public Defender to represent you. You also qualify for what's called pretrial release, which is a non-monetary release. You'll be released as it relates to this charge today. Because there's no victim here, I have to order that you have no contact with the alleged victim, and that you and the alleged victim maintain separate residences until further order of the court. If you need to go back to the residence one time, or if you need to go back to the residence to get any personal belongings, you can do so one time with the presence of law enforcement. Other than that, you gotta maintain separate residences, you and the alleged victim. Also order that you possess no weapons, firearms, or ammunition. Other than that, you'll be released as it relates to this charge today with those conditions, okay? All right, good luck.
Counsel?
Yeah. Did I appoint, I think I appointed him.
I thought he said.
Oh, yes?
I think I did. If not, I appointed the Office of the Public Defender to represent you, so you have an attorney going forward, okay? All right, good luck.
Yana Karas, refuse.
All right.
I will waive.
It's an out-of-county warrant.
Oh, okay.
So what do we do? Yeah. All right. Yeah, we'll waive his appearance. It's an out-of-county warrant, set at no bond. We'll leave it's a VOP. We'll leave the bond set at none.
And Hannah Hughes is bonded.
All right, good for her. All right, sir, your name?
Mr. Anderson.
All right, Mr. Anderson, you're here on a violation of probation.
Sir.
I'll appoint the Office of the Public Defender to represent you. I'm gonna stay the bond at none. You're also here on a driving while license suspended and reckless driving. We'll set bond on count one. I do find probable cause for those offenses as well. I'll set bond on count one at $1,000 and count two at $250, okay? Well, you have an attorney appointed to represent you. You have the right to remain silent. You're not entitled to a bond on a VOP. You probably want to go see the judge. You have an attorney appointed to represent you on that case.
Just got my son waiting at home on me.
I don't know what to tell you. So you're gonna have to go see the judge, where the VOP is pending before you get a bond on that case, okay?
Your Honor, can you give me the case number for the CT, please, for the dwellers?
Yep. 2022 CT 7075
Thank you.
and 7076.
Thank you.
All right, sir, your name?
Daquan Miles.
All right, Mr. Miles, you're here in 2021 CF 3644AO. It's a violation of probation warrant. The judge had signed the warrant, set the bond at none. I'm gonna stay the bond at none until you go see that judge who signed the warrant. I'm appointing the Office of the Public Defender to represent you. So you have an attorney appointed to represent you. You're gonna be held no bond till further order of the court, okay? Good luck. Oh,
They filed their notice.
well,
I have it on the court minutes.
they're about to put to work. About to get put to work. All right, so that was it for the morning?
Yeah.
Yeah, we'll do those. All right, 33-day motions. This is 2022 CF 13133AO Calendaria.
Denied, information was filed.
Say 14. All right, Duarte, 2022 CF 11796 AO.
Denied, information was filed.
All right, 2022 CF 12765 AO, Langlaze.
Denied, information was filed.
All right. Plotkin, 2022 MM 7633 AO.
Granted, notice of non-filing.
And 2022 CF 12990 AO.
I'm sorry, Your Honor, what's the name?
You're gonna make me say it. Saz Natal. Yeah.
Granted, notice of non-filing.
All right, we'll be, what time's everyone want to come back? All right, sir, the offer from the state to resolve your case is an adjudication of guilt and credit for time served, plus the court costs. You'd be released as it relates to this charge today. So what would you like to do?
To go home, sir.
Yeah, all right, you understand that by resolving your case, you'll be entering a plea to a criminal offense and you're waiving the rights to go to trial? All right, there's a plea form in front of you. Go ahead and sign that plea form. We'll go over it real quick with you, okay?
Your Honor, do you have the case number? Because on my sheet, it doesn't have one.
I have 2022 MO 1371.
Oh, sorry, I didn't sign. Nothing to the plans.
Christmas.
You too.
Hopefully not. Sure.
All right, it's handed a plea form, appears to have your signature at the bottom. Did you sign this plea form? You understand that by resolving your case here today, that there's not going to be a trial and that you're waiving the rights listed on the top of the plea form? All right, including your right to an attorney?
That's right.
All right. You understand if you're not a U.S. citizen, a plea to a criminal offense will subject you to deportation?
Yes, sir.
All right. You understand if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment? All right. You on probation for anything else? All right. It was a no contest plea. We'll accept the no contest plea. We'll adjudicate you guilty. Sentence you to, what, 2 days? Sentence you 2 days in the Orange County Jail with credit for the 2 days that you have already served. So you'll be released as it relates to this charge today. Also assess court costs. Give you 1 year from the date of your release to take care of the court costs, or else there's going to be a suspension on your driver's license, okay? All right, good luck.
Thank you, sir.
And in this case, for some reason, I don't get the case numbers for the city cases, Your Honor. Do you have the case number for his new law violation for Mr. Anthony Johnson, Anthony?
2022 MO 1372. It looks like it's one case. I have an out on bond form, but I don't know if it,
We are going to resolve both, Your Honor.
okay.
Um,
Oh, yeah, 1182 is the other case.
Sorry.
Right?
Sorry, I have an injury, sorry.
That's all right.
Yes, Your Honor, the offer as to the new law violation 2022 MO 1372 AO is an adjudication of guilt, credit time served, and court costs in case number 2022 MO 1182 AO. The offer from the state is a withhold, credit time served, and court costs. And Mr. Johnson would like to accept and enter a plea of no contest.
All right. Mr. Johnson, you heard what the attorney had to say. Is that your understanding of what's going to happen here today?
Yeah, I'll go home.
Yeah, I hear you. I was handed a plea form. Did you sign this plea form?
Yes, I signed, just signed it.
All right. You understand that by resolving your cases here today, that you're waiving your rights associated with going to trial that are listed on the plea form,
Yes,
including your right to an attorney?
yes,
All right. All right. You understand that if you're not a U.S. citizen, a plea of this offense will subject you to deportation?
yes,
You understand if you've ever been convicted of a sexually motivated or sexually violent offense, a plea of this offense could subject you to involuntary civil commitment?
yes,
All right. You're on probation for anything else?
no.
All right. We'll accept the no contest plea to each case.
Okay.
In 2022 MO 1372 AO, will adjudicate you guilty, give you, credit for the, it's 2 days again? Or is he- That's all right.
Okay.
Yeah, since you're 2 days in the Orange County Jail with credit for the 2 days that you've already served, so you'll be released as of that charge today. Also, order you pay court costs, will give you 1 year from the date of your release to take care of your court costs. Also, 2022 MO 1182AO will withhold adjudication, sentence you to 2 days in the Orange County Jail with credit for the he's 3? 39. Got 39 days on that one. So we'll sentence you to 39 days in the Orange County Jail with credit for the 39 days that you already served. You'll be released as it relates to that case as well. Also ordered to pay court costs, give you 1 year from the date of your release, take care of the court costs, okay?
Okay, so I go home today?
Should be.
Okay.
All right, good luck to you, sir.
You're welcome. You're welcome.
Yeah. Yeah. All right, sir, your name?
Michael E. Allen.
All right, Mr. Allen, you're here on one count of urinating in public. That's a violation of the city ordinance. Is there an offer to resolve this case?
No. There is. If you any objection to ROR? Does he have a phone? I'll ask. Something I should ask.
All right,
You want to,
some competency.
Oh, he does. He was giving me the number, sorry.
then, yeah, no objection.
Your Honor, there was an offer to resolve, but he's been deemed incompetent to proceed. I would ask for an ROR. State has no objection as long as he maintains contact with the attorney.
All right, well, appoint the Office of the Public Defender to represent you. We'll release you ROR on the condition that you maintain contact with your attorney and attend all scheduled evaluations, okay?
Your Honor, what I'm actually asking for is that we enroll in e-notify, which is something with the clerk system.
Mhm.
When I ask if they have a phone.
Oh,
and
I'm
that way
putting it in.
They can be notified of their upcoming court dates.
Okay. Do I need to order him to enroll in e-notify? If so, I can.
I'm writing it on his sheet, Your Honor. Do you have the case number? So they'll have all that.
1375.
1375, thank you.
Well, also as a condition of your release order that you enroll in the e-notify system. That way you can be notified of any future court dates, okay?
Okay.
Main thing is just that you're gonna go home today. Just need to show up to court. Save those for. All right, sir, your name?
Nathaniel Tony.
All right, Mr. Tony, you're here on a warrant, 1 count of conspiracy to commit first-degree murder, 1 count attempted first-degree murder with a firearm, 1 count aggravated battery with a firearm, and another count of aggravated battery with a firearm. Say, he's not entitled to a bond on counts 1 and 2, right? All right, the judge who signed the warrant set bonds on count 1 and 2 at 0. I'm gonna stay those bonds at none. And also counts 3 and 4, the bonds were set at $10,000. I'm gonna stay those bonds at $10,000. I'm gonna appoint the Office of the Public Defender to represent you, so you will have an attorney appointed to represent you going forward. File any appropriate motions as it relates to your bond or anything else, okay?
You want to no contact with the
Yes.
or any witnesses, no weapons or firearms, no return to the scene.
As a condition of your bond too, I'm also gonna order that you have no contact with any of the alleged victims or witnesses, that you possess no weapons or firearms, and that you do not return to the scene where this was alleged to have taken place, okay? Yeah. Counts 1 is none, counts 2 is none, counts 3 and 4, $10,000. Yeah. No. All right, sir, your name?
Good morning, Your Honor. My name is Mikael Abrahams.
All right, you're here for an in-jail arraignment. The Office of the Public Defender has been previously appointed. It's 1 count driving while license suspended or revoked with knowledge.
We're gonna,
Counsel, what are we doing with this one?
Enter a plea of not guilty, Your Honor.
All right.
Division 83, pretrial conference, January 9th at 8:30, courtroom 6C.
You guys need this? All right, thank you, sir. That's your next court date. All right, sir, your name?
Jason Allen.
All right, Mr. Allen, you're here for an in-jail arraignment. It's one count of fraudulently engaged in activity where a license was required. The Office of the Public Defender's been previously appointed. This is in Division 62. Counsel, what are we doing with this one?
The offer from the state is a withhold of adjudication, credit time served, and court costs. Mr. Allen would like to accept the state's offer and enter a plea of no contest. Additionally, Your Honor, he's being, when he was arrested, I believe there were multiple counts. However, the state only filed on this count, so the attorney assigned did file a motion to be heard in conjunction with his arraignment.
Okay, once we enter the plea, we'll delete the bonds on the
Thank you.
unfiled charges, okay?
Thank you.
Yeah. Okay. I mean, on the unfiled, he's entering a plea to the fraudulently engage in activity where license was required, but they didn't file on the other charges. Well, we can, I mean,
Your Honor, can you just enter the order? I think there is an order attached for our consent.
yeah. There we go. That's easy.
I have one.
And just put count 2 through 5.
Mhm.
You're releasing him after?
Yeah, I don't want to ROR him because he's not going to be out. I mean, he's resolving the case, so I just want to really, I mean, I don't know how to
I
say
have
it.
the order.
There's no action taken. Okay.
Yeah, let's,
I could
yeah.
email it to,
Okay.
you print it, Mr. Eugene, if I email it to you? Thank you.
I just don't want if it's something else happens, they pick him up and think he's out on bond on something he's not out on bond on. All right, sir, your name again?
Jason Allen, sir.
All right, I was handed a plea form. It appears to have your signature down at the bottom. Did you sign the plea form?
Yes.
All right, did you hear everything your attorney had to say? Is that your understanding of what's happening here today?
Yes, Your Honor.
All right, you understand that by resolving your case here today, there's not going to be a trial and that you're waiving the rights listed at the top of the plea form?
Yes, sir.
All right, you understand if you're not a U.S. citizen, a plea of this offense will subject you to deportation?
Yes, sir.
You understand that if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
Yes, sir.
You on probation for anything else?
No, I've never been on probation.
All right,
This is my first offense.
yeah, that's all right. All right, we'll accept the no contest plea to the count that was filed on. We'll withhold adjudication, sentence you to 33 days in the Orange County Jail with credit for 33 days that you already served, so you'll be released as it relates to this charge today. Also order that you pay court costs. I'll give you 1 year from the date of your release to take care of the court costs. If after a year, there's still a balance of the court costs, the clerk's gonna suspend your driver's license, okay?
Yes, Your Honor.
All right, so with regards to the unfiled counts, has he got an order on that?
Yes.
We're going to, you'll be released on, as it relates to this case today. Yeah, I'll take it. Yeah, delete it. I'm going to delete the bonds on counts 2, 3, 4, and 5, so you should be released as it relates to this charge today, okay?
Thank you, Your Honor.
Thank you. Let's see. That was Alan. Which is plea form too. All right, sir, your name?
Bruno Fernandez.
All right, Mr. Fernandez. It's case 2021 MM484AO. It's one count of petty theft over $100 or more. It's going to be a plea, counsel?
Yes, Your Honor, the offer from the state is a withhold of adjudication, credit time served, no return to the Walmart located at 11250 East Colonial Drive, and court costs. Mr. Fernandez would like to accept and enter a plea of no contest.
All right, Mr. Fernandez, did you hear what your attorney had to say?
Yes, sir.
That's your understanding what's going to happen here today?
I do not understand. This is my first time doing anything like this.
Yeah, but you understand that you're entering a plea to a criminal offense today, and you'll be released as it relates to this charge today?
Well, yes, sir. Thank you.
Yeah, I just handed a plea form. Appears you have a signature at the bottom. Did you sign this plea form?
Yes.
All right. You understand that by resolving your case here today, there's not going to be a trial on the petty theft count, and that you're waiving the rights associated with going to trial?
Okay.
Do you understand that? You understand you have the right to go to trial on this offense, right?
Yes, sir.
All right. You know what a trial is?
Yes, sir.
All right. You know you have the right to call your own witnesses and to confront the state's evidence. You understand that?
Yes, sir.
All right. And you understand you have the right to have the state prove the charges against you beyond a reasonable doubt? And that by resolving your case here today, you're waiving those rights. Do you understand that?
Yes, sir.
All right. You on probation for anything else?
No, not that I know of.
Okay. You understand that if you are on probation for a separate offense, a plea to this offense might be used to violate that probation? Do you understand that? And do you understand if you're not a U.S. citizen, a plea to this offense will subject you to deportation?
Yes, sir.
All right. You understand that if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
Yes, sir.
All right. Counsel, it's a no contest plea?
Yes, Your Honor.
All right, we'll accept the no contest plea. We'll withhold adjudication, sentence you to 6 days in the Orange County Jail with credit for the 6 days that you've already served, so you'll be released as it relates to this charge today, okay? Also order that you do not return to the Walmart at 11250 East Colonial Drive, and that you pay court costs. Court costs will give you 1 year from the date of your release to take care of the court costs. If you don't take care of the court costs within a year, the clerk's going to suspend your driver's license, okay?
Sir.
All right, good luck to you, sir.
Thank you so much. God bless you guys.
All right, your name?
Jada Reddick.
What happened to Naris?
I saw that he pled already, Your Honor.
Okay, all right, just making sure. All right, your name again, ma'am?
Jada Reddick.
All right, and PD's been previously appointed in this case as well?
Yes.
All right. All right, ma'am, you're here for an arraignment. It's petty theft of $100 or more. Counsel, what are we doing with this one?
Entering a plea of not guilty, Your Honor.
All right, is this a VOP or is this a? On the, all right, so it's fair, so it'll be a denial?
Denial, yes.
Yeah, okay.
Division 84, VOP status, January 17th at 8:30, courtroom 4B.
All right, that's your next court date. You have an attorney appointed to represent you, so, good luck to you.
Thank you.
All right, your name?
Andy Alexander.
All right, Mr. Alexander, you are here on 1 count of resisting officer without violence, 1 count of possession of cannabis greater than 20 grams, or less than 20 grams. I've reviewed the arrest affidavit. I do find that there is probable cause. I'll appoint the Office of the Public Defender to represent you. So you're gonna have an attorney appointed to represent you. I'll set bond on count 1 at $250. Count 2, set bond at $100. You're also out on bond, a battery, 2022 MM 2914AO.
Your Honor, I believe he was arrested May 9th, and to date, no information has been filed.
Yeah, I'm gonna appoint the Office of the Public Defender in that case as well. I'm gonna take no action on his bond, given the nature of there's probable cause, but barely, on the new law stuff. So I'm gonna take no action on his battery bond.
Your Honor, I'll just clarify the record with regard to the outcome bond.
Yeah.
It was actually no bill that
Okay,
paperwork just hasn't made it to the clerk's system yet.
okay.
So I think there may also be a detainer, if all of that could be addressed, but it really is supposed to be a closed case.
Okay,
So the no action is fine, I'm just trying to clarify the record why.
perfect, okay. Well, we'll take no action on it, so he should be released as to both charges today. Well, he's got bond on the new charge, but he was not gonna be, you're not gonna be held on the old battery case.
Old.
Yeah,
Closed, sir.
yeah. We're just making sure we're all on the same page, which I think we are, okay?
All right, so question,
Yeah, you have bonds on your new case.
how much is that? 200 usually. All right, thank you.
Yep, thank you. All right, ma'am, your name? Name, your name?
My name is Kathleen Augustine Critchlow.
All right, Ms. Augustine, you're here on one count of loitering and prowling. I reviewed the arrest affidavit. I do not find there to be probable cause. State, do you have any argument as to probable cause on this one? I mean, it's a parking lot in the middle of the day.
Understood, Your Honor. However, I believe pulling on the door handle
So I don't,
while there was an individual inside of a car,
so you might have to repeat what he's saying for me to understand.
I believe, and she did not.
The accent is so, like, yeah, it's kind of,
I think the alternative, Your Honor, is an attempted burglary conveyance.
Yeah, I'm gonna find no probable cause. But I understand the argument.
so when you tell me something, I can't.
I'm gonna ROR her today, appoint the Office of the Public Defender to represent you. So you're gonna be released as it relates to this charge today. I will order, I guess I can't. I'm just gonna ROR her today.
Thank you.
All right.
That's it.
Your Honor, Bronson refused.
All right, PD's been previously appointed in the case she was out on bond on, so I'll go ahead and appoint the Office of the Public Defender to represent her on the new case. I know in the case she's out on bond on, the attorneys filed a notice of suggestion of incompetency.
I believe she uploaded in the system also the eval done by the doctor stating that Mr. Bronson has been deemed incompetent to proceed. Well, is incompetent to proceed. I believe the only thing now is to have the judge sign the order, Your Honor. But it is uploaded in the system.
All right, well, I've reviewed the arrest affidavit. I do find there is probable cause. In the new cases, I'll stay the bonds on each count based on the competency proceedings in the other case. I'm gonna toll Speedy in this case as well. And I'm gonna take no action on the case he was out on bond on. All right?
No return.
Yes, no return to, what was this? This was like overall.
See liquors?
ABC, yep. I looked at this too. The other one he was out on bond on was a different place. That, the court factored that into taking no action. So I think the other one was a Ross. So this was an ABC. We'll have a no return to the ABC. All right, sir, your name? Sir, your name?
Ricardo Chavez.
All right, Mr. Chavez, you're here on one count on trespass on property after warning. I've reviewed the arrest affidavit. I do find there's probable cause. I will appoint the Office of the Public Defender to represent you. Was there an offer to resolve this one?
No, Your Honor.
Okay.
Well, there was, right? But, okay, because he's on probation.
All right. So I'll stay the bond on this case at $500. Order that you do not return to the 7-Eleven at 1201 North Cimarron Boulevard, okay? And all right, sir, your name?
Christopher Eric Cron.
Gerald? All right, I'll appoint the Office of the Public Defender to represent Mr. Gerald waive his appearance? All
The
right,
offer to resolve, can we try for tomorrow, Your Honor? And if-
yeah, we can reset it tomorrow, reset it for an offer. I reviewed the affidavit, I do find the probable cause will, for now, we'll stay the bond at 500, but we'll reset it tomorrow. All right, and you're Mr. Cron?
Crone, yes, sir.
Crone? All right. You're here on one count of petty theft.
Yes, sir.
I reviewed the arrest affidavit. I do determine there's probable cause. I'll appoint the office of the public defender to represent you. Is there an offer to resolve this case?
No, Your Honor.
Okay, all right. We'll stay the bond at $250. Also order that you do not return to the Walgreens, okay?
Yes, sir.
All right, good luck to you.
Thank you, sir.
All right, sir, your name?
Jesus Antonio Marquez Jr.
All right, Jesus Antonio Marquez Jr., you are here on one count of trespass on property after warning. Viewed the arrest affidavit, do determine there's probable cause. Was there an offer to resolve this one?
In this case, Your Honor, the offer is an adjudication of guilt, 15 days in the Orange County Jail with, I believe there's credit for 2. No return to 505 Edgewater Drive. In court costs that Mr. Marquez would like to accept.
All right. All right, Mr. Marquez, you heard what the attorney had to say. Is that your understanding what's going to happen here today?
Yes, Your Honor.
All right. I'm being handed a plea form. Do you have the opportunity to go over that plea form?
Yes, Your Honor.
You understand that by resolving your case here today, you're waiving the rights listed at the top of that plea form. There's not going to be a trial?
Yes, Your Honor.
All right. You understand if you're not a U.S. citizen, a plea to this offense will subject you to deportation?
Yes, Your Honor.
All right. You understand that if you're on probation for a separate offense, a plea to this offense will be used to violate that probation?
Yes, Your Honor.
And do you understand if you're not, if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
Yes, Your Honor.
All right. Well, accept the no contest plea. We'll adjudicate you guilty, sentence you to 15 days in the Orange County Jail with credit for 2 days' time served. We'll also order that you do not return to the Shell gas station at 5051 Edgewater Drive.
Yes, Your Honor.
And also order that you pay court costs, give you 1 year from the date of your release to take care of the court costs, okay?
Yes, Your Honor.
All right, good luck to you, sir.
You're welcome.
All right, sir, your name? All right, Mr. Merritt, you're here on one count of carrying a concealed weapon. I've reviewed the arrest affidavit. I do find that there is probable cause. I'll appoint the office of the public defender to represent you, and I'm gonna stay the bond at $500, okay? And also order that you do not possess any weapons or firearms or ammunition, okay? As a condition of your release. Good luck to you, sir. What? You got a bond of $500.
They'll tell you.
They'll tell you. All right, sir, your name?
Rohan Taylor.
All right, Mr. Taylor, you're here resisting an officer without violence, disorderly, one count disorderly intoxication, one count defrauding an innkeeper less than $1,000. I reviewed the arrest affidavit. I do determine there's probable cause. I'll appoint the office of the public defender to represent you. On count 1, I'm going to set bond $500. Count 2, 100. Count 3, 100. As a condition of your bond 2, I'm also going to order that you do not consume any alcohol or illegal drugs, okay? All right, good luck to you, sir. Oh, and also, yeah, thank you. Do not return to the palace at 5526 South Orange Blossom Trail, okay? All right, good luck to you. All right, sir, your name?
Robert Walker.
Not related, are we? Yeah.
Your Honor, the offer from the state to resolve the trespass is a withhold of adjudication, credit time served, and court costs. Mr. Walker would like to accept it as a plea of no contest, and in return for him resolving the trespass, I'd ask that you take no action on the out on bond.
That's all right. Here's what I don't know if I have PC. I don't know if I have a factual basis for the trespass, because they're alleging that he trespassed. He was in a car without being authorized, licensed, or invited. I know the car was stolen, but, I mean, is that a trespass state? I mean, there were other people in the car. There's no allegation that he knew the car was stolen. He's not charged with the stolen vehicle. So if like my buddy comes up and says, hey, you want to ride up to the gas station, and I get in the car, am I trespassing? I don't know. And if the car's stolen? Because
I have no argument at this time, Your Honor. Looking at the affidavit, it doesn't indicate that the ignition was punched.
Right.
There are no signs that it was stolen.
Right.
And there's nothing in here to indicate that anyone else would have.
All right. So I'm going to ROR you on the trespass. So you're going to be released as it relates to the trespass without having to enter a plea, okay? And I'm also going to take no action because of the lack of probable cause on the new law violation. I'm going to take no action on the case that you were out on bond on, okay? On the trespass. Took no action on the, yep. Good luck, sir. Try to stay out of trouble. You're on bond on your other case still, so. All right, sir, your name?
Tony Wilson, sir, Your Honor.
All right, Mr. Wilson. You're here on one count of resisting an officer without violence. I reviewed the arrest affidavit. I do determine there's probable cause. Is there an offer to resolve this one?
No, Your Honor, he's on probation.
All right. I'll appoint the office of the public defender to represent you, okay? I'm going to stay the bond in this case at $500. Say I have a bond, but yeah, you can go take care of your VOP. All right? Sir, your name?
Daniel Winkler.
All right, Mr. Winkler, you're here in one count of possession of drug paraphernalia. I've reviewed the arrest affidavit. I do find there is probable cause.
Your Honor?
Yep.
With regard to 22 MM 8368, possession of drug paraphernalia, state announces no information.
All right. State's not going to file charges on this, so you'll be released as it relates to this charge today, okay? All right, good luck. All right, sir, your name? What, your name?
Zay Johnson.
All right, Mr. Johnson, you're here on one count of disorderly conduct. I've reviewed the arrest affidavit. I do determine there's probable cause. Is there an offer to resolve this, or do you make offers on these states?
I do not.
Okay, all right.
Yes, I do.
The offer was a withhold credit time served and court costs. You just signed it. Mr. Johnson would like to accept the state's offer and enter a plea of no contest.
All right, this is 2022 MO 1373 AO. Mr. Johnson, it's been represented to the court. You're going to resolve your case here today by entering a plea. Is that your understanding?
I don't understand the difference. I'm not really good with courts.
All right, you understand you're charged with it's a misdemeanor. It's a criminal offense. You understand you're charged with a criminal offense of disorderly conduct? You understand that?
I understand that's the name of it.
Yeah. It's essentially that you block traffic. It constitutes disorderly conduct according to this section of the statute. Do you understand that? You do? I'm just asking. I'm just trying to make sure we all know what we're doing here, okay?
Yeah, I understand that's the charge and everything.
All right. You understand you have the right to go to trial on that charge? You know what a trial is?
I think so.
Huh?
I think it's to go to court.
All right. We're not going to do a plea today. Any objection to ROR state?
No objection, Your Honor.
All right, you're going to be released as it relates to this charge today. Just the condition is that you show up to future court dates, okay?
Yes, sir.
So your case is not resolved here today. You're going to get out. You're going to get court dates in the future. You need to, I'll appoint the Office of the Public Defender to represent you. So you have attorneys to appoint to represent you. You need to get in contact with them as soon as you get out, okay?
Okay, that's today?
Should be, unless something's else holding you. You'll be released as it relates to this charge today, but you should be released today, okay?
Yes, I will be here back.
Johnson?
Is there particularly, any, a fine?
Nothing, no, you're not resolving your case here today.
Didn't resolve the plea, so you call them.
No.
Okay, well, I appreciate that.
Yeah, good luck. All right, your name?
Tuấn Ngọc Nguyễn.
You have the case number, Your Honor, I'm sorry.
Yeah, 2022 MO1374AO. All right, sir, you're here one count of disorderly conduct. I reviewed the arrest affidavit. I do determine there's probable cause. Looks like, well, let's see, was there an offer to resolve this case?
Yes, Your Honor, of an adjudication credit time served.
All right.
And Mr. Nugent would like to accept and enter plea of no contest.
All right, Mr. Wayne, you heard what the attorney had to say. Is that your understanding what's happening here today? You got to answer out loud, yes or no?
You
You got to answer out loud, yes or no, so.
Yes.
I was handed a plea form, appears to have your signature down at the bottom of the plea form. Did you sign this plea form?
Yes, sir.
All right, you understand that by resolving your case here today, there's not going to be a trial and that you're waiving the rights listed at the top of the plea form?
Yes, sir.
All right, you on probation for anything else?
No, sir.
All right, you understand that if you're not a U.S. citizen, a plea of this offense will subject you to deportation?
Yes, sir, I understand that.
All right, do you understand that if you've ever been convicted of a sexually motivated or sexually violent offense, a plea of this offense could subject you to involuntary civil commitment?
Yes, sir.
All right. All right, we'll accept the no contest plea. We'll adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. You'll be released as it relates to this charge today. Also going to order that you pay court costs. I'll give you a year from the date of your release to take care of the court costs, okay?
Thank you, Honor.
All right, thank you. Good luck. All right, sir, your name?
Emmanuel Strickland, Emmanuel Bartholomew Strickland.
All right, Mr. Strickland. You're here on one count of open container. I've reviewed the arrest affidavit. I do find that there's probable cause.
Your Honor, the offer from the state is an adjudication of guilt, credit time served, and court costs. Mr. Strickland would like to accept and enter a plea of no contest.
All right. All right, Mr. Strickland, attorney had indicated you want to resolve your case by entering a plea today. Is that your understanding?
Yes, sir.
All right, you understand that that plea form you're signing, that by entering a plea here today, you're waiving the rights that are listed at the top of that plea form?
I understand this.
Right. You understand that if you're not a U.S. citizen, a plea of this offense will subject you to deportation?
I do understand.
All right. Do you, are you on probation for anything? All right. Do you understand that if you are on probation for something else, a plea to this offense could be used to violate that probation?
I understand.
All right. You understand if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
I understand.
All right. We'll accept the no contest plea, adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. You'll be released as it relates to this charge today, okay? Also, order that you pay court costs. I'll give you a year from the date of your release to take care of the court costs, okay?
All right, yes, sir.
Good luck.
Thank you.
All right, sir, your name?
Good afternoon, Your Honor. My name is Todd DeRutter.
All right, Mr. DeRutter, you are here on one count of driving under the influence. I've reviewed the arrest affidavit. I do determine there's probable cause. I will appoint the Office of the Public Defender to represent you. I'm gonna set bond in this case at $500. Also order that you do not, hold on. I'll also order that you do not take any narcotics without a valid prescription and that you take them as prescribed, okay? All right, good luck to you, sir. Yep. All right, sir, your name?
Jeremy Eason.
All right, Mr. Easton, you have two cases. I think both of them are failure to appears. One's a failure to appear on driving while license suspended, revoked, or canceled with knowledge. The other one's, I believe it was a registration. Yeah, no motor vehicle registration. Was there an offer to resolve this case?
The offer from the state is a withhold of adjudication, credit time served, and court costs.
On each case?
Yes, Your Honor, and Mr. Easton would like to accept and enter a plea of no contest.
All right. Let me ask, counsel, was this from the same stop, the Dwillis and the registration? Do you know?
From what I read, Your Honor, it was.
Okay, I think it was too. So I'm gonna just do court costs on one, if that's okay.
Yes, thank you.
All right. All right, sir, you heard what the attorney had to say. Is that your understanding what's gonna happen here today?
Yes, sir.
All right, you understand that by resolving your case with a plea, you're entering a plea to a criminal offense and you're waiving the rights listed on the plea form? Gotta answer out loud, yes or no?
Yes, sir.
Yeah. I see you shaking your head, but everything's being transcribed by a court reporter somewhere else, okay? These are cases 2022 CT 1667 AW and 1666 AW. You understand that if you're not a U.S. citizen, a plea to this offense will subject you to deportation? And do you understand that if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment? All right. We'll accept the no contest plea on 2022 CT 1666 AW. Will withhold adjudication, sentence you to, how many days does he have? You know, two? No. But he's the 13th, it's a failure to appear. I don't, was he arrested on the original?
2 days on 6666, 2 days on both cases.
All right. Sentence you to 2 days in the Orange County Jail with credit for the 2 days you've already served. Also order that you, so you'll be released as it relates to that case today. Also order that you pay court costs. I'll give you 1 year from the date of your release to take care of the court costs. If you don't do that, there's gonna be another suspension on your driver's license, okay? All right, on the 1667 AW, will withhold adjudication, sentence you to 2 days in the Orange County Jail with credit for the 2 days' time served, no further sanction. You'll be released as it relates to that case today too, okay?
Yes, sir.
All right, good luck to you.
You want just a clarification, you're waiving the court costs on 1667, correct?
Yeah, the registration, yeah. All right, sir, your name?
Gerard Ferreira.
All right, Mr. Ferreira, you are here, hold on 1 second. You're here on 1 count of DUI. I've reviewed the arrest affidavit. Do determine there's probable cause. I'll appoint the office of the public defender in that case, and I'll stay the bond at $500. Also order that you do not consume any alcohol or any illegal drugs or any prescription medication without a valid prescription. State he was out on bond on trafficking and GHB. Does the state have a position on, I mean, they're kind of related if you.
Your Honor, that's a statewide prosecution. It looks as though they're trying to resolve it with a plea in February, I believe, but it is a statewide case.
I'm gonna take no action on, you're out on bond on the trafficking and GHB case. You're not entitled to a bond if you get new law violations while you're out on bond. So I could revoke your bond, and you'd be held no bond until you resolve that case, or until you see a judge. I'm not gonna do that today. I'm gonna take no action on that case. Do you have an attorney in that case? You do? Okay. All right. So I'm taking no action on that case. You were out on bond based on the nature of the new law offense and the representations that it's likely or working towards a resolution. So anyway, you should be released or you have a bond on the new law violation. You're not being held on the case that you're out on bond on, okay? All right, good luck to you, sir. All right, ma'am, your name?
Vanessa Henderson.
All right, Ms. Henderson, you're here on a failure to appear warrant. It came in no bond. Was there an offer to resolve this case?
Yes. The offer from the state is an adjudication of guilt, credit time served, you want to? Okay. And, Ms. Henderson would like to accept and enter a plea of no contest. We were just discussing the suspension on her driver's license.
All right. Let's go over HTO with her.
Yes.
Okay.
In this case? Your Honor, do you show, she's stating she has a private attorney for this case, actually.
Do we have an NOA for her in this case? Do we see? Hang on, I'll look.
Well, he's gonna see if they filed. Definitely.
Yeah. NOA was filed today.
Yep, that's what she stated.
Yeah.
Oh, you're fine.
All right. So we're not going to take a plea today. State any objection to, based on the credit time served offer, RR. I mean,
I apologize, Your Honor, only because it's an FTA.
yeah, that's true. That's true. That's true. All right, you do, all right, the bond came, the warrant was signed, it came in at none. I'm gonna set bond at $250, okay? You gotta show up to court. You have an attorney, hired an attorney to represent you in this case.
Yes, sir.
That should help you show up to court. You just make sure you stay in contact with them. Cause if you don't show up to court again, you know, you're not entitled to a bond, okay? All right, so you have a bond on this case, $250. Yeah,
Your Honor, understanding the reason that you have set a bond, I would still object, only because, again, it's an FTA. And unless it's going to be in your courtroom, or it says that it can be changed, the bond should remain as is.
what division is it, 80? Who's division 80? Not that it may make, not that it will make a difference, I'm just curious. Do you know, who's division 80? Do you know which one? Yeah, she normally doesn't sign warrants with no bond, so the fact that she did, I'm gonna stay the bond at none, okay? I don't know why, it's because a different judge signed that warrant. She usually doesn't issue no bond warrant, so for some reason she did, so I'm not gonna touch it, so I'm gonna stay the bond at none. Thank you, State. And so you'll be held on this until, further order of the court, okay? All right.
Your Honor, Ramirez Rodriguez bonded,
All right.
and Torres responded also.
I don't know if I have Torres. Oh, that's Torres, yeah. All right, ma'am, your name? All right, Ms. Alford, you're here one count of burglary of an occupied dwelling. I've reviewed the arrest affidavit. I do find that there is probable cause. I'll appoint the Office of the Public Defender to represent you. I'm gonna stay the bond at, say the bond at $5,000. What's that? It's at 5,000, isn't it? Yeah. Stay the bond at $5,000. Order that you do not return to the residence where this was alleged to have occurred. That you have no contacts with any of the alleged victims or witnesses, okay? All right, good luck, and if I didn't already, I'll appoint the Office of the Public Defender to represent you, so you have an attorney, okay?
Sure.
Uh-huh. All right, sir, your name?
Maurice Brown.
All right, this is case 2022 CF 14228 AO. Failure to report every 30 days as a registered sex offender. came in no bond indicating to be set at IA. It's what we're here on today. I'll set bond at $2,500 with the condition that you comply with all reporting requirements within 2 business days of your release. You're out on bond on the same charge, 2022 CF 8687 AO. I'll appoint the public defender to represent you in that case too.
It looks like, I don't know, no information has been filed, Your Honor. From what I can see, it looks like the warrant was issued July 26th of this year.
The warrant was issued in that case?
Yes, but it was weird. It looks like there was something done on it, but I don't see any type of filing decision made based on my system. I don't know if the state has more, but it just looks like the warrant was issued, he was served, but nothing was done after that.
Your Honor, I can confirm that he was arrested November 1st and he hasn't filed formal charges. It does look as though the case was initiated back in July.
When he bonded out, was there conditions that he comply within? Can you see that? Let me look. Yeah, all right. There's a $500 bond on that case, and the conditions were that you check in within 3 days of release.
I did that, sir.
I'm not saying you didn't, but then you got a new one.
That new one I had COVID. I was diagnosed with COVID. You can check that
Sorry,
ORMC.
I'm gonna take no action on the case you're out on bond on. You have a bond on the new one at $2,500, okay?
Right.
And if you do bond out, the conditions are that you report within 2 days, okay?
Okay.
All right, I know it's hard, it's a lot of hoops to jump through, but it's what you gotta do, okay? All right, good luck.
Your Honor, Kane is behavior.
I will waive if you appoint, Your Honor.
Yeah, on both of them, yeah. All right, he has, what, 5 cases? They were all warrants. So I'll appoint the public defender's office. They weren't previously appointed in each of his cases. His behavior, yeah. We'll stay the bonds in 2022 CF 14095 AO, stay the bond at $1,250. In 2020, yes?
I don't know if you'd like to do a blanket. These are, I believe, are all petty theft or theft, retail. Can you also do a no return for all of them, please?
Yes. All right, so in that case, 14095, no return. We'll stay the bond in 8206 AO at $1,000, also with a no return. 2022 MM6934 AO, stay the bond at $2,000, no return. And 2022 MM6285 AO, stay the bond at $2,000 with a no return. And there's one more. 2022 MM6284 AO, stay the bond at $2,000 and a no return. We do Brown, yeah, we did Brown. Kane is who we just did. All right, ma'am, your name? Your name?
DeVoe, Sherry.
Oh, sorry. All right, Ms. DeVoe, you're here, 1 count of attempted second-degree murder with a weapon. The probable cause determination's been previously made. I've reviewed the affidavit to issue the warrant. Stater, do you have a position as to an appropriate bond?
Oddly enough, Your Honor, she actually is entitled to to a bond, it's just a first-degree felony.
Right.
Barring.
I read the allegations, and ma'am, I'm not gonna ask you about the facts of your case, because you have the right to remain silent. I don't want you, everything you say can and will be used against you. I'll appoint the office of the public defender to represent you, and I would advise you not to, I'm gonna talk to the attorneys, I advise you not to say anything, okay? I read the allegations, and it was essentially an argument with a male over money in the parking lot, and then she stabbed him. Yeah, I mean, there's probable cause for what she's charged with, but do you have, as to the amount of bond, do you have a position?
I don't, Your Honor.
Okay, all right. I'm gonna set bond in this case at $25,000. Order that you have no contact with the alleged victim or any witnesses. And also that you possess no weapons, firearms, or ammunition, okay? And those will be the conditions of your bond. You have an attorney appointed to represent you, okay? All right, good luck. All right, sir, your name?
Gary Dorseyville.
All right, you're here, one count of possession of MDMA. I've reviewed the arrest affidavit in that case. Do you find there's probable cause? I'm going to stay the bond in that case at $1,000. You're also out on bond on burglary of a structure and petty theft in case number 2022 CF2422AO. Has charges been filed in that case?
Yes, Your Honor, pre-trial is set for February 22nd.
Do you have a position stayed on, on the bond in that case? The one he was out on bond?
Your Honor, only because of his history, I would ask that you revoke and hold him at no bond.
My only argument would be, Your Honor, he picked up a non-violent offense. If you are inclined to revoke, you would revoke and maybe consider doubling the bond as opposed to holding him at no bond.
He was ROR'd, so here's what I'm doing. I am gonna revoke the bond on that case. I'm gonna set bond to that case in $10,000. So you have a bond on it.
And you're doing 10,000 on count 1 and 2, or?
10,000 on count 1, count 2, we'll do, $250.
Okay.
All right? All right, you have attorney appointed to represent you in each case, so, good luck to you. Okay. All right, sir, your name?
Eric Folsom.
All right, Mr. Folsom, you are here on a warrant for failure to register as required. The bond on the warrant was $1,500 with the conditions that you were to comply with all sex offender reporting requirements within 2 business days of your release from jail. You're also out on bond on the same offense.
Yeah. One was supposed to be dropped because they came and picked me up on the same one that I'm out on bond on.
It's all right. Yeah, you have bond of $1,500 on this one. I'm gonna take no action on the one that you're out on bond on. But but the requirements are that you register within 2 business days of being released, okay?
Thank you.
Your Honor, Gandy is refusal.
All right, we'll appoint the Office of the Public Defender to represent Mr. Gandy. It's 1 count of possession of cocaine, 1 count of possession of cannabis less than 20 grams.
I will waive, Your Honor.
All right, we'll stay the bond on count 1 at 1,000, stay the bond on count 2 at 150. Got another? Oh, also has 22 MO 1377 AO. I'll point, we point the PD on MO cases?
Yes,
We do, yeah,
Yes,
all
Your
right. Yeah, I mean, they're criminals, so. At 1 count, we'll appoint the PD in that case. It's 1 open container. We'll set the bond of that one at $100.
On the first place, the possession of
Stayed, both of them. Sir, your name?
Antonio Garcia.
All right, Mr. Garcia, you're here on one count of aggravated assault with a deadly weapon. I've reviewed the arrest affidavit. I do determine there's probable cause. I'll appoint the Office of the Public Defender to represent you. Let's stay the bond at $3,500. Also order that you have no contact with any of the alleged victims or witnesses, okay? All right, good luck.
Your Honor, Goldman is behavior.
All right, I will appoint the Office of the Public Defender to represent Mr. Gobin. He's here on failure to appears, carrying concealed weapon and possession of cocaine. You waive his appearance, counsel?
Yes, Your Honor.
All right, we'll stay the bonds on count one, $2,500, count two, $250.
Johnson Darius bonded.
All right, sir, your name? All right, Mr. Johnson, you're here. One count of failure to register. Failure to report driver's license, office name change. I came in at no bond. And it doesn't, my review of the warrant did not indicate whether it could or could not be modified. IAs.
He's entitled to a bond, Your Honor.
That's true. It's not a failure to appear. All right, so I'm gonna set bond on count one at $2,500. $2,500 I'm gonna require, and a condition of your release will be that you comply with all reporting requirements within 2 business days of your release, okay?
So, one thing I had was a address.
Then you gotta, yeah, that's it. It's a failure to report. So I've appointed the Office of the Public Defender to represent you, so you have an attorney and you have a bond now too, with the condition that you comply with reporting requirements, whether that's change the address, whatever it may be, within 2 business days of your release, okay? All right, I did. All right, sir, your name? All right, Mr. Joseph, you're here for a warrant for failure to appear. The bond in that warrant signed by the judge has bond set at 0. I'm not entitled to a bond on a failure to appear. I'm gonna stay the bonds at 0 until further order of the court. I'm gonna appoint the Office of the Public Defender to represent you, okay? All right, good luck. All right, sir, your name?
Ryan Ming.
All right. Brian Ming?
I don't know why they put my middle name as my name on here.
Patrick?
That's my middle name.
All right, so we're talking about the same person. I'm just making sure. So,
His AFIS is clear.
all right. All right, you're here, 1 count of possession of fentanyl, 1 count of possession of drug paraphernalia. I've reviewed the arrest affidavit. I do determine there's probable cause. I'll appoint the Office of the Public Defender to represent you. I'll stay the bonds on count 1 at 1,000, count 2 at 150. Also, as a condition of release, order that you possess and consume no illegal narcotics, okay? There's a,
There should be a CT or traffic.
oh, does he? Hold on 1 second. Oh. You're also here, driving while license suspended or revoked with knowledge. In 2022 CT 7077, I'll appoint the Office of the Public Defender to represent you in that case as well. I'll set bond to that case in $250. Okay? Good luck.
You're welcome.
Your Honor, Philip Damon bonded.
All right. All right, sir, your name?
Randy Phillips.
All right, Mr. Phillips, you're here, 1 count grand theft 3rd degree, and 1 count resisting a merchant. I reviewed the arrest affidavit. I do determine there's probable cause. You also have, in 2022 CF 14458, One count possession of oxycodone, one count possession of alplazoram, one count possession of cocaine, one count aggravated battery on a law enforcement officer, one count resisting officer with violence, one count fleeing or attempting to elude an officer, one count driving while license suspended or revoked. With regards to the theft case, I'm gonna stay the bonds on count one at 500. I'll appoint the Office of Public Defender to represent you in both cases. The theft case, I'll stay the bond on count one at 500, stay the bond on count two at 100. Order that you do not return to the Dick's Sporting Goods. On the other case, I'm gonna set bond on count one at $250, count two, $250, count three, $250, count four, set bond in that case at $25,000, counts 5, 6, and 7, you're gonna set bond at $250. All right, good luck to you.
Monica Delas, you bonded,
All right.
and Reynolds is mental health.
I will waive if you appoint me.
Reynolds, you said?
Yes, it's mental health.
All right, we will appoint the Office of the Public Defender to represent Mr. Reynolds. You waive his appearance?
Yes, Your Honor.
All right, well, reviewed the arrest affidavit, do determine there's probable cause, stay the bond on that case at 5,000.
No return, Your Honor?
Oh, yes, no return to the address 702 Hillcrest Street. All right, sir, your name?
Jamal Robinson.
All right, Mr. Robinson, you were here, one count of possession of MDMA, one count of possession of cannabis less than 20 grams. I reviewed the arrest affidavit, do determine there is probable cause. I'll appoint the Office of the Public Defender to represent you. I will set bond on count, I'm gonna stay the bonds on each count. Count one, 1,000, count two, 100, okay?
How much is 1,000? How much that is?
It's $1 more than $9.99. It's up to a bail bondsman. Whatever you and a bail bondsman work out, it's usually 10%. So it's usually $100.
All right, sir.
Yeah, good luck.
I want my mom to.
Your Honor, Rosa bonded,
All right. Name, your name? Your name?
Gabriella Sander.
All right, Ms. Sander, you're here, one count possession of cocaine, one count of possession of drug paraphernalia. I've reviewed the arrest affidavit, do determine there's probable cause. I'll appoint the Office of the Public Defender to represent you. I'll stay the bond on count one at $1,000 and count two at $100, okay? All right, good luck. All right, sir, your name?
Morning, Your Honor. Anthony Santana.
All right, Mr. Santana.
Your Honor, I do have a PC challenge.
All right.
As to the burglary of a conveyance. Based on the arrest affidavit, there is no indication that anything was taken from the vehicle or stolen. My client alleged that he was merely sleeping in the vehicle. I would argue there's no PCS to the burglary of a conveyance, because in order to have the burglary of a conveyance, there must be a crime that's committed therein.
State.
Your Honor, I believe it can be inferred that if someone breaks into a locked vehicle and therefore enters, that a crime is going to be committed.
Yeah. Based on the allegations, I understand defendant's argument. I am going to find there's probable cause. You know, his statement's contrary to the allegations, you know, while maybe a defense, I am going to determine there's probable cause. I'm going to stay the bond at $3,500. Also, was this a parking lot, counsel? Or was it a driveway? Do we know? Anyway, regardless, I'm gonna order you do not return to 4855 South Orange Blossom Trail. And go back to where this was alleged to have occurred, okay? All right, good luck. Yeah.
He stated at 5. Okay. No action on the item. Okay.
All right, ma'am, your name?
Raisha Williams.
All right, Ms. Williams, you are here on a warrant. Count 1, principal in the first degree of attempted murder. Count 2, principal in the first degree robbery with a firearm. I reviewed the allegations in the affidavit. Say, do you have a position as the amount of appropriate bond?
Your Honor, these are first-degree felonies punishable by life or actually life felonies. I ask defendant be held no bond.
Defense? I'll appoint the Office of the Public Defender to represent you, so you do have an attorney appointed to represent you, okay?
Your Honor, given the limited criminal history, I'd ask that you use your discretion to set a bond. She's been in the Orlando area for over a year, no failures to appear, and the only thing on her record appears to be a trespass when she was a juvenile and a battery. You do have the discretion to set a bond. I just ask that you use your discretion.
All right. I'm gonna stay the bonds at, are we sure this is a principal in the first, this is a punishable by life?
Yes, Your Honor. I made sure that even a principal is the same, especially in this case, Your Honor, where the allegation is that this defendant set up the meet.
Right.
So yes.
No, I read it, and yeah, so I'm gonna stay the bonds at none, until further order of the court. You have an attorney appointed to represent you, to file any and all appropriate motions, okay? Lucky he's alive.
How are you?
Is that it? You got it. All right, we'll be in recess till tomorrow when Judge McGinnis is back.
Good afternoon, ma'am. Can you state your name and date of birth, please?
Bonisha Kinlock, 09/17/1988.
Okay, Ms. Kinlock, I am appointing the public defender to represent you today. You are here on one count of burglary of an unoccupied dwelling, one count of possession of marijuana, one count. Just a moment. I'm just reading you the charges. I'm going to hear from your lawyer shortly. One count of resisting without violence, and one count of trespass after warning. Counsel, would you like to be heard?
Yes, Your Honor. With regard to the charge of burglary, the statute defines it as that, you know, the breaking and entering into a property with intent to commit a felony therein. Nowhere in the affidavit does it show any intent to commit a felony, so I would challenge probable cause as to the burglary charge.
State any response.
Your Honor, I believe it's intent to commit a crime there, and it states that while Andrews was not home, the defendant threw away their belongings in the trash and locked herself in the above residence, thereby going towards a trespass and a destruction of someone else's personal property.
One moment, let me just look at the affidavit again. What portion are you referring to?
It starts on the very last sentence of the first page and going into the first paragraph of page 2.
Okay. And so your position then is that the intent shown, the offense that she allegedly had the intent to commit when entering the home was trespassing or something other, trespassing and what, or what else, destruction of property?
Yes, Your Honor, the trespass and the destruction of property.
Okay. Counsel and defense, any response to that position regarding the language in the first really the first sentence where it indicates that threw away belongings and trash, locked herself in the above residence.
I thought the language was intent to commit a felony there, and I'm trying to find the statute exactly right now.
I'm looking at it now, it's 810.021A. Entering a dwelling, structure, or conveyance with an intent to commit an offense therein, unless the premises at the time are open to the public or the defendant is licensed or invited to enter.
No response there, Your Honor. I'm sorry.
Okay, that's okay. All right, so the court will find probable cause on all four counts. On the burglary count, bond will be set at $1,000. On the possession count, $100. On the resisting arrest count, $100. And the failure to leave upon order, the trespassing count, $100. As a condition of bond, ma'am, you are not to return to the scene of the alleged crime. You're not to have any. Ma'am, just a moment. I'm happy to hear from your lawyer. Let me finish explaining the term. Let me finish. If you just let me finish explaining the terms of your release. You are not to return. You are not to have any drugs or non-prescription medications. You are not to have any contact with the alleged victim in this case. Counsel, is a one-time return an issue in this case or no?
Yes, Your Honor, we'd like to get a one-time return with law enforcement to get her belongings.
How am I gonna get my clothing?
State any objection to a one-time return?
No, Your Honor.
Okay. I'm going to, ma'am, Ms. Kinlock, I'm going to permit a one-time return under the supervision of law enforcement to recover any personal belongings. Otherwise, you'll have no contact, maintain separate residences from the alleged defendant.
Thank you, sir.
Alleged victim, okay?
Yes, sir.
Best of luck to you, ma'am. Okay. I didn't see any interpreter cases this afternoon, but can you just confirm that for us?
I have one, Your Honor. Alishka Gerardo. Is it a Spanish interpreter? Gerardo.
Okay. He can approach, or she?
Good afternoon, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
Good afternoon, Mr. Barrera. We're here for initial appearances. I've called case 2022 MM 2757. The defendant is Alishka Guerrido. Ma'am, can you please state your name and date of birth?
Señora, por favor, dígame su nombre y su fecha de nacimiento despacio voz alta.
Aleixka Guerrido, 1123 del 94.
Alicia Guerrido, 1123 of 94.
All right, ma'am, I am appointing the public defender to represent you today.
Le voy a designar las oficinas del defensor público que la representen usted en el día de hoy.
You're here on two charges, one count of resisting arrest without violence and one count of battery, touching, or striking.
Usted se encuentra en dos cargos, uno de resistir un agente del orden público sin violencia y otro cargo de agresión, tocar o golpear.
I have reviewed the charging affidavit and determined that there is probable cause for the charges.
He revisado la affidavit de cargos, determino que existen indicios razonables para las alegaciones.
Bond will be set on the resisting count at $250.
La fianza estará programada en el cargo de resistir por $250
And on the battery count at $1,000.
y en el cargo de agresión la fianza será $1,000
That's with pretrial release, with PTR.
con condiciones de libertad provisional.
As a condition of release, ma'am, you were not to have any contact with the alleged victim.
Como condición de su libertad se le prohíbe trato con la presunta víctima.
And you are to maintain separate residences. I wasn't clear if y'all reside together, but if maintain separate residences is a condition as well.
Y no estaba seguro si ustedes residen juntos, pero una de las condiciones de su libertad es que no convivan y que no tenga trato con él.
Anything further from the state?
¿Algo más, Fiscalía?
No, Your Honor.
No, señoría.
Defense?
¿Defensa?
Your Honor, she doesn't appear to reside there, so she doesn't need the one-time return.
Okay,
Su señoría no parece residir, por lo tanto no necesita regresar una sola vez.
okay. Best of luck to you, ma'am.
Buena suerte, señorita. Thank you.
Is that it for interpreter cases, Mr. Rosa?
Yes, Your Honor.
All right, that's all we need today, Mr. Burrow.
You're welcome, Your Honor. Have a good afternoon.
Have a good one. All right, Jessica Jenkins.
Your Honor, she's currently detoxing and asked for a reset for tomorrow.
Okay, we'll do a 24-hour reset for Ms. Jenkins. Nathaniel Titus Lynch.
Your Honor, he's indicating he has a private attorney, but he would like the public defender appointed for today's purposes.
Okay, thank you, sir. Can you state your name and date of birth?
It's Nathaniel Lynch, 4/14/2000.
Okay, Mr. Lynch, I am provisionally appointing the public defender to represent you today. You're here on a out-of-county warrant from Orange County. What's the warrant for? You will be bond was set at 0. You're going to be transferred to Orange County. Bond will remain at 0 at this time. Anything further, state?
No, Your Honor.
Defense?
No, Your Honor.
All right, best of luck, Mr. Lynch. David Alexander Sly.
In the cage, Your Honor. One moment.
Sure. Good afternoon, sir. Can you state your name and date of birth?
David Alexander Sly, 8/21/93.
All right, Mr. Sly, I am appointing the public defender to represent you today. You are here on an out-of-county warrant arrest for aggravated assault with a weapon. Bond was set at 0 in the warrant. It's going to remain at 0, and you're going to be transferred to Orange County. Best of luck, sir. Anything further, Mr. Rosa, on that case?
No, Your Honor.
All right. All right, Nicole Danielle Unke. Good afternoon. Can you please state your name and date of birth?
Nicole Danielle Onquay, 9/10/2000, or, yeah, 09/10/2000.
All right, Ms. Unque, I'm appointing the public defender to represent you. You're here on an arrest warrant, one count burglary of unoccupied conveyance, actually 2 counts of burglary of an unoccupied conveyance and 1 count of criminal mischief. Probable cause was previously found by the judge executing the warrant. I have also reviewed that and determined probable cause exists. Bond was set on count 1 at $5,000, count 2 at $2,500, and count 3 at $1,000. It's going to remain as set in the warrant, and the conditions will remain the same, which are no return to the scene of the alleged crime, World Food Trucks, and no contact with the alleged victim. Anything further from the state?
No, Your Honor.
Defense?
No, Your Honor.
No return to scene. Yeah. Thank you, ma'am. Best of luck to you.
Thank you.
Ludeca Lozano Perez. Good afternoon, ma'am. Can you state your name and date of birth?
Good afternoon, my name is Ludeca Lozano Perez, birthday 10/23/1991.
All right. I am appointing the public defender to represent you today. You are here on an arrest warrant for violation of probation. Bond was set at 0. It's going to remain at 0 at this time. Best of luck to you, ma'am.
Your Honor, do we have a court date, a next court date?
Just a moment. No, for Ms. Lozano Perez. Did you catch that, counsel?
I did not.
VOP arraignment, January 3rd, 8:45 a.m., courtroom 5A.
Thank you, Your Honor.
Thank you. All right. Irving David Lennon.
Approaching, Your Honor.
Good afternoon, sir. Can you state your name and date of birth?
Irving David Lennon III, 62271, Your Honor.
All right, Mr. Lennon, I am appointing the public defender to represent you today. You are here on an arrest warrant in case 2017 CF 3000 for violation of probation. Bond was set at 0. It's going to remain at 0 at this time. Yep.
Your Honor, may I ask what the violation was for?
The warrant violation of probation by failing to live without violating any law by being charged with criminal offense of driving while license suspended or lesser included on November 26, 2022 in Lake County, Florida. A violation of Condition 5 by failing to live without violating law by being charged with the criminal offense of failure to register a vehicle on November 26, 2022 in Lake County, Florida, and violation of Condition 3 by leaving county of residence without consent of probation officer.
Your Honor, may I add to that? I do have a travel permit that does allow me to leave county for work purposes.
Okay, and I trust that you will be able to take that up with the division judge. At this time, I'm looking at a warrant arrest for those alleged violations. They're allegations at this time. You have a hearing set for December 21 at 8:30 a.m. in courtroom 4F for your arraignment. And
To be reinstated?
I'm sorry?
No, that's for the Lake County, correct?
No, sir. Is that here? Or?
That's a VOP
Yeah, that's your VOP.
At court too.
That's your VOP arraignment for this case, sir.
Okay.
Okay?
All righty, so the 21st is when I go back.
Yes, sir.
Thank you, Your Honor.
Best of luck, sir. Douglas James Hunter III. Good afternoon, sir. Can you state your name and date of birth?
Douglas James Hunter III, 11585.
All right, Mr. Hunter, I am appointing the public defender to represent you today. You are here on a violation of probation charge. Bond was set at 0. It's going to remain at 0 at this time.
Yes, sir. Do I have a court date on my next court date?
Just a moment.
VOP arraignment December 21st, 8:30 a.m. courtroom 4F.
What my violation was for?
Violation of Condition 1 of the order of probation by failing to report the probation officer as directed. In that, on April 21, 2021, offender was instructed by officer to report to probation office on April 23, 2021, and offender violated his, on the belief that offender violated his probation, and that you then failed to report. That's the allegation, sir.
All right, thank you.
Okay?
So a court date for me for my next court date?
It was December 20, you can just tell me, I don't think they're hearing you for some reason. December 21st at 8:30 a.m.
All right, thank you.
Best of luck, Mr. Hunter. Demarius Hart.
Your Honor, Mr. Hart is currently still with law enforcement.
Okay. So will he be here? You want us to call him later, or are we resetting?
I asked for a reset. I don't think he's going to be here.
Okay, so we'll reset for tomorrow. All right, Amber Nicole Fountain.
Present approaching, Your Honor.
Good afternoon, ma'am. Can you state your name and date of birth?
I'm Amber Nicole Fountain, 042989.
Okay, Ms. Fountain, I'm appointing the public defender to represent you today. You're here on a bench warrant arrest for failure to appear for arraignment. Bond was set at $2,000. It's going to remain at $2,000. Best of luck to you, ma'am.
Thank you, Judge.
And I should be clear about that because there's two charges. There's one failure to appear on written promise and another failure to appear on written promise. One bond was $1,500, the other was $500, so it's a total of $2,000.
Okay, do I have a court date on this?
I don't know if there's a court. Is there a court date on for Ms. Fountain? I can look it up. What's the case number? You have arraignment scheduled for December 21st at 8:30 a.m. in courtroom 4F.
Can you repeat that, Your Honor? I'm sorry.
Sure, no problem. It's arraignment December 21st, 8:30 a.m. in courtroom 4F. Best of luck, ma'am. Omar Aguilar.
Your Honor, can we call him up last?
Sure.
Thank you.
Kevin Duda. Good afternoon, sir. Can you state your name and date of birth?
Kevin Duda, 7269.
All right, Mr. Duda, I'm appointing the public defender to represent you today. You're here on two cases. On case 2022 MM 497, the charges of resisting arrest without violence. I have reviewed the charging affidavit and determined that there is probable cause for that charge. Bond will be set at $250. On case 2022 MM 2756, you're here on a warrant arrest for violation of probation. Bond was set at $0. It's going to remain at $0 in that case. Anything further from the state?
No, Your Honor.
Defense?
Your Honor, if I may, the violation of probation is 22 MM 497.
I got them reversed. I apologize. No,
Your
not
Honor, is there a court date?
on the VOP.
Yes, Your Honor.
Do you have a date? December 22nd, 8:05 a.m., courtroom 5B. And just for the record, I reversed the case numbers. Your VOP case is 22 MM 497, and your new charge of resisting arrest is case 22 MM 2756. But the bonds, as indicated, will stay. Okay? Best of luck. Frank Failing.
It's in the cage approaching, Your Honor.
You sure? Good afternoon, sir. Can you state your name and date of birth, please?
Frank Joseph Fowling, 11/15/1995.
Okay, Mr. Failing, I am appointing the public defender to represent you today, the lawyer standing next to you. You're here on 3 counts of battery on a law enforcement officer, firefighter, EMT, et cetera. I've reviewed the charging affidavit and determined that there is probable cause with respect to the nurses. Can somebody help me out with the security officer and whether or not the statute would cover that? I was a little bit uncertain on that issue. So I have the statute pulled up, and it defines emergency medical care providers to include nurses. So the nurses certainly qualify. And then the other individual, is listed as a security guard employed at that address at the hospital. Would that person be covered under the statute? Can anybody help me out with that?
Your Honor, I believe it would cover the statute I'm looking at under 784.072B. This part says licensed security officer who wore a uniform that bore at least one patch or emblem that was visible at all times, that clearly identified the employing agency, and that clearly identified the person as a licensed security officer.
Can you say that number again? 2B, you said?
Yes.
I'm not seeing that. Is that are we sure I'm looking at the right one? 784.07 2B. I have it as reading in case of battery for misdemeanor of the first degree to a felony of the third degree. You can approach if you're looking at a particular. Oh, you have a computer.
Yes.
I mean, it's a little bit semantic, but I just want to make sure that yes, you may approach, yeah.
So I believe the first one that I was looking at was the annotated, but when I click on here,
Whenever a person is charged.
it starts off like in the middle.
Okay, I see where you are.
Your Honor, I think I may have incomplete information here. Who is the alleged security officer in this
The arrest, or the charging affidavit states that on the first page, it discusses the names of the nurses, and then it says Reed Mays is a security guard employed at the above address. And my understanding from the affidavit is it was the two nurses and that security officer who are the alleged qualified individuals under the statute. The nurses most certainly apply under the definition of emergency medical care provider. And I'm trying to find out if this security officer would also apply. And the state has appointed me to 784.072, which I was reading at the moment.
Yes, Your Honor. And in addition to the statute, a licensed security officer is also a qualifying person under the jury instructions for the same statute.
Because law enforcement officers defined as any person who is a current member of law enforcement agency's Explorer program and who is becoming, okay, and who is performing functions other than those required to be performed by sworn law enforcement. Defense, anything you want to add to this? I know I'm kind of creating my own problems here, but.
I would only add that the affidavit doesn't explicitly say that he was identified as a security officer when going to restrain. It just states that he went to the room to attempt to restrain the defendant, so I would ask that no probable cause be found with respect to the security officer.
State, here's the language that I'm hung up on, which is 1D, where it defines what a law enforcement officer is. A law enforcement officer, a correctional officer, a correctional probation officer, a part-time law enforcement officer, a part-time correctional officer, an auxiliary law enforcement officer, an auxiliary correctional officer, and any county probation officer, an employee or agent of the Department of Corrections who supervises or provides service to inmates, an officer of the Florida Commission on Offender Review, federal law enforcement officer, and law enforcement personnel of the Fish and Wildlife Commission. So from that, it doesn't appear that a security officer would be considered a law enforcement officer.
Well, Your Honor, I could see under 1D your point, but they charged and arrested him under Section 2B, which does fall under. That's where you'll see the language about a security officer.
Okay, a person licensed as a security officer is defined in. Okay, I appreciate you helping me with that. I'm going to find probable cause on all three counts. Thank you for indulging me in that. Officer Jenkins, this defendant qualifies for direct PTR with mental health, or?
Mental health acts for, seeking, he get ROR because they gonna Baker Act him. He's gonna be Baker Act.
He's going to be Baker
Yes.
Act.
Your
Okay.
Honor, I would ask that he be ROR because he's gonna be taken, he's gonna be Baker Act and taken directly to Park Place.
State, would you like to be heard on that?
They would not object to him being transported to Park Place.
So if I order PTR, he cannot be Baker Act? Is that what you're saying? Okay. We have an interesting system, don't we? All right. So no objection from the state to an ROR for purposes of allowing a Baker Act?
Well, the state would be objecting to ROR.
Can I bring this?
Yes.
This is some of the stuff that's going on with him. And I know this morning he had a real bad seizure. So it's a lot, they say, that's going on with him.
It does appear that there's some significant issues that need to be addressed. I don't know that,
I'd also add, Your Honor, that he has 3 other cases that are currently in the middle of competency proceedings. I don't know exactly where they are at the moment, but I know that he has other cases where competency is an issue.
Thank you. State, anything further you want to add?
No, Your Honor.
All right, so I will ROR with the understanding, I'm not ordering it, but from the representations made that there will be a Baker Act, he will be released on his own recognizance. As a condition of release, the defendant is not to return. Oh, no.
Oh, he probably having another seizure.
Yeah. Yeah.
Mm-hmm.
He's been ROR'd, so they can take whatever necessary actions they need to at this point to protect him.
know how much you can see, Your Honor, but he's currently being evaluated by the staff here.
Sure, understood. Take all the time you need, obviously. We'll go off the record. Maybe I should stay on.
No, he was in the hospital, he had seizures. Yeah, he had seizures when he was in the hospital, and then he had one this morning. When we spoke to him this morning,
So they have seizures, right? They are like knocked out.
my nephew, he had a real bad, he'd be out.
Yeah, like light.
Oh, I got him in a chair, that's good. Okay, ready to proceed?
Yes, Your Honor.
All right, so I think I concluded that, but I said ROR, no return, and no contact with the alleged victims. All right. Idalise Otero. Good afternoon, ma'am. Can you state your name and date of birth?
Idalise Otero, January 16, 1996.
Okay, Ms. Otero, I'm appointing the public defender to represent you today. You're here on two cases. On case 22MM2758, the charge is driving while license suspended. I have reviewed the charging affidavit and determined that there is probable cause for the charge. On case 22CT4310, charged with providing a false name or ID by an arrestee. I reviewed the charging affidavit and determined that there is probable cause for that charge. Officer Jenkins, she applies for direct PTR?
Yes, sir.
Okay. Any objection state to direct PTR with no bond?
No bond.
No, sure.
Okay, so you,
Sorry.
that's okay, ma'am. You qualify for direct pretrial release per the administrative order, and so you're going to be ordered to direct PTR with no bond. Okay? Best of luck.
Okay, thank you.
All I have left is Omar Aguilar, is that correct?
Yes, Your Honor.
Okay. Good afternoon, sir. Can you state your name and date of birth?
Omar Aguilar. Ladies, we're still in court. Omar Aguilar, March 28, 1980.
Mr. Aguilar, I'm appointing the public defender to represent you today. You're here on three bench warrants. Bench warrant in case 2019 CF 3717 for failure to appear for a status hearing. Bond was set at 0. It's going to remain at 0 in that case. In case 2020 CF 411, failure to appear for status hearing, bond set at 0, it'll remain at 0. And in case 2021 CF 1371, failure to appear for status hearing, bond set at 0, and it will remain at 0. Anything? We have some court dates if you would like.
So for all cases, competency status hearing, February 1st, 9 a.m.
February 1st, 9 a.m. for all cases, a competency status hearing.
February 1st.
Anything further from the defense?
No, Your Honor.
No,
State?
Your Honor.
All right, thank you. Thank you, sir. Best of luck to you. Anything, anybody, did we miss anybody?
We got them all, Your Honor. Thank you.
Thank you. Have a wonderful afternoon.